Item number 30, RSA 160 of 2024.
Appeal admitted.
Item number 31, CRP IO 316 of 2024.
Petition dismiss.
My please, Lord. I'm praying for a listing of a second appeal on the coming Friday, my lord. Urgency is in the sense that, my lord, suit has been allowed.
This week not possible. Next week any date.
My lord, urgency. is
Next
there.
week. Sorry.
On 18th September.
May I please, Your Lordship?
Hmm.
Item 25 and 26, Lordship. Other such concern also, Lordship. After week, Lordship.
25 and 26. When?
After week.
After 2 weeks. You
Lordship.
inform the other side.
1 week, Lordship. 1 week.
You are for?
Petitioner, Lordship.
Pet-
J. Akhtar, Ms. J. Akhtar,
You inform the other side.
Lordship.
Your good name?
Ms. J. Akhtar,
Ms. J. Actor, Learned Counsel appearing on behalf of
M. Khan,
Mr. M. Khan, Learned Counsel for the petitioner or respondent.
Petitioner, Lordship. Petitioner, Lordship.
M. Khan is a respondent here. Hmm?
25 of respondent, 26 of petitioner. 25 of opposite party of the petitioner.
In 25, you take down. Learned Counsel for the respondent number 6. With consent from the other side, press for listing the matter after 1 week. 1 week. E2 26 for the petitioner.
At this is Lord.
Apply.
My lord, with due consent of the other side, my lord, I beg to mention item number 29, my lord. Here in this case, my lord, learned counsel, Mr. M.A. Strasbourg, we was supposed to do that. My lord, he is suffering from illness, my lord. My lord, may I pray, my lord, this matter may be come up after 2 weeks, my lord.
You are for the petitioner or respondent.
My lord, we are for the appellant.
I'm for the petitioner, Lordship. Item number 29.
As agreed by learned advocates of both the parties, this is a list the matter after 2 weeks.
Obliged.
May I please your lordship? A criminal petition matter, my lord. Some urgency there supposed to be listed. I have filed an IA for interim, my lord. The registry is saying it is kind of matter to be listed before your lordship, my lord. May it be on 13th?
When?
On 13th, my lord.
Next week.
The urgency is there, my lord.
Next week.
Next week, my lord.
On 18th September.
18th.
Yeah, please. I beg to mention item number 17, 18 and 19 that has been fixed for hearing today, Your Lordship.
17 and 18.
17, 18 and 19.
Lordship, in this matter, I am for the respondent, my lord. My lord, one matter fixed on similar matter fixed on 19th of September. My lord, this matter may be fixed on 19th of September.
Your Lordship, actually, we are going to submit written argument. 2 matters are fixed with them on that particular day. Your Lordship, it will be a bit active for me to do the same matters. Another day may be fixed, Your Lordship. 26 September may be fixed.
26.
26 September. I'll submit written argument, Your Lordship.
Okay. Your good name?
M. Chatterjee.
Miss M. Chatterjee.
Yes, Your Lordship.
Learned Counsel for the
For the appellant.
with consent from the other side, press for listing the matter on
26th.
26 September. Yes.
Obliged.
May I please, your lordship? Permission for listing the matter on 16/9/2024, lordship.
16 not possible. Lordship. Already so many cases on Monday. On Friday, 20 September.
I'll have lordship.
May I please, your lordship? Recommendation for listing of 2 RFS. For urgency, due to certain urgencies, we require to list the matter. So our
This
Thursday,
week not possible, next week.
One on 20 September, one on 23rd September.
can it be on 20 September vote?
So many lot of it.
Pay pillar. Not with consent of other side, I beg to mention item number 15 and 16. Matter may be adjourned for the day.
15 and 16.
15 and 16.
15 and 16.
Yes, yes. On behalf of B Sinha,
Your good name?
A Islam.
Sir H. Islam, Learned Counsel, appearing on behalf of Mr. B. Islam, Learned Counsel for the appellant with consent from the other side. Price for listening the matter when?
After 3 weeks.
After 3 weeks. Why 3 weeks? This is 2014 matter.
Mr. Business, some personal difficulty.
After 2 weeks.
Pledge.
May I please, Your Lordship? I pray for listing of a CRPIO for admission and next week, Lordship.
On 20 September.
And another matter for orders. We are delay in notices issued thereafter not listed in the month of June.
On 25th September.
May it please your lordship, I'm beg to mention an item for withdrawal, your lordship, anytime, any date next week.
Which matter?
RSA, your lordship, for withdrawal. Parties
When?
have reached a compromise, any date next week, your lordship.
On 16th.
Obliged.
May it please your lordship, I beg to mention item number 5, your lordship. Your lordship, in this matter, S.K. Singh, senior counsel, your lordship, was appearing in person. So today was fixed, but unfortunately his father advocate K.P. Singh is in ICU, your lordship. So he could not leave the place at Tejpur, your lordship. So may I pray that this matter may kindly be taken up on 16th of this month, your lordship. I have taken the consent of the other side.
I limit your lordship, my earlier organization had the matter in full.
Yes, earlier.
And he assured also that he is competent and authorized by the.
Your lordship, last time the matter was adjourned, as his presence was
I limit your
filled, your
lordship.
lordship.
Since
I'm praying for time on behalf of Mr. S.K. Singh, whose father is admitted in the ICU, your lordship.
I limit your lordship, my lord.
No, when do you want?
16th of this month, your lordship.
Okay then.
Next
16.
month.
As agreed by learned advocates of both the parties, recess and list the matter on 16th.
On 33.
May I please, your lordship. With consent of other side, I beg to mention.
Mr. Posilal,
I'm sorry, your lordship. Actually, he gave the consent and thereafter.
no, that's all right. Another IA is linked with this petition.
Yes, that will also be tagged up. I suppose the last time it was not tagged up.
Okay,
Obliged, your
same
lordship.
order. This IA shall be tagged with the CRP IO 88 of 2020.
May I please, your lordship. With consent of other side, I beg to mention item number 24, lordship. This matter may come up after 2 weeks, lordship.
24.
24, lordship.
When?
2 weeks, lordship. 2 weeks, lordship.
When?
2 weeks.
2 weeks.
2 weeks, lordship.
Your good name?
N Brahma, lordship.
And
N Brahma. Petitioner, lordship.
learned counsel appearing on behalf of
Petitioner. On behalf of G. Bhardwaj, lordship.
G. Verdas, learned counsel for the petitioner with consent from the other side. Price for listening the matter after 2 weeks. PRL.
Please, my lords. My lords, may I pray for the listing of an IA in connection of an MSc appeal for release of 50% security deposit that was deposited with the registry.
When?
It's a small IA, my lord. This week, if it's possible, my lord.
COVID?
It's a short IA.
On 20 September.
I'm very obliged.
May it please the lordship. Lordship, I beg to mention 3 numbers of RFA for listing.
When?
Lordship, Friday possibly.
Not possible. Next week. Take a date from him.
For hearing order,
It is for orders.
one on 25th and rest on 27th.
25th.
One on 25th and the rest on 27th.
Actually, they are similar matters linked together.
Okay, on 25th.
Like,
May please your lordship. That's why I have to mention for listing IA along with in MSC appeal number 138/2020 madam. The matter was settled, but the insurance company assured to me that payment would be made within 4 weeks. 6 months already had gone, my lord, payment was not made.
When do you want?
My lord, 17 or 16, my lord, listed.
17? Possible?
Last week of September, on 23rd. 23rd September.
So late, my lord, 21st.
Sorted, possible sorted.
17, my lord. Orders matter, my lord. Simple IA, my lord.
Maybe, but the order has to be passed.
Yes.
28th September, 20.
Yes. Yes.
My plead lordship, I beg to mention for listing of a RSA, matter is relating to this matter.
When?
Next week,
On 23rd September.
22.
May please the lordship. Lordship, I wish to mention for listing of an MSC bill which was last posted on 21/11/2022. Any day lordship up to lordship's
On 27th September.
lordship, and similar prayer with respect to another MSC bill which was last posted on 8/5.
On 30 September.
Similar matters lordship. File on same
Okay, okay.
for orders.
May it please, sir. My lord, on 11th May, my lord, 3 numbers of appeal, my lord, MSc appeal, my lord, listed before the Loko Adalat, my lord. Those who are not, my lord, settled, my lord. Some urgency is there, my lord. May I pray, my lord, any convenient date in the next week, my lord. 3 matters, my lord.
3 May.
Before vacation, hearing may not be possible.
Before vacation, any convenient date. my lord.
We have lot of part-heard matters before vacation. So your matter may not reach.
My lord, may not be this, but my lord, any convenient date, my lord, may I pray, my lord.
Before vacation may not be possible.
Yes, after vacation, my lord. Immediately after vacation, any date, my
The
lord.
date will be fixed by the AGPs.
Immediately after reopening.
May it please your lordship, I have to mention item number 27, lordship. We are the appellants, lordship. We have filed affidavit in reply in this matter.
27.
Yes, lordship. The same is not on record, lordship. The matter may be adjourned for the day and may be posted next week, lordship. Maybe on 17th or 19th, lordship, as per your convenience.
Yes, Mr. Das. Any objection? No.
No. I think 17 or 19 would be better. It is pending for last 3 years.
Okay. As agreed by learned advocates of both the parties, registration lists the matter on COVID.
On 17 May.
Obliged, lordship.
Items from daily list for motion bail application. Item number 1.
This is on second bail application, earlier bail application, page 27, rejected by coordinate bench.
Oh, right.
What is your pair?
My prayer is lordship that some observation is there, page 28, lordship may kindly see. That
No, earlier it was rejected by another coordinate bench.
not rejected actually, lordship, disposed of, because this court held that there was inordinate delay on the part of the prosecution. And thereafter, one opportunity was given to them that within 6 months they will conclude. Otherwise, trial court will decide my bail application in terms of lordship that Ravi Prakash judgment. That observation was there, and it was not concluded within 6 months. That is why I am again before your lordship. Page 28, lordship may kindly see that observation, paragraph 6. And paragraph 10(9) also read that.
At that time, Honorable could observe that some delay on the part of the petitioner's lawyer also, my lord. That cannot be
No,
treated as.
that was never observed in the order.
No.
If it is,
However, it
this
is-
6 month delay is occurred due to that
yes,
accused
yes,
person, then he will not be entitled
yes.
for any benefit. That
However,
was the observation.
it is made
Page
clear.
30, that observation is there. So we are not at fault.
Okay, let the status report come.
Up to the status.
Heard Mr. A. Ahmed, learned counsel for the accused. And also heard Mr. K.K. Parasar, learned additional PP for the state respondent. This second bail application is prepared by accused Tajuddin under section 483 of the BNSS 2023. Who has been languishing in jail as in connection with a special NDPS case number 40 of 2022. Arising out of Pathakandi PS case number 69 of 2022 registered under section 21C, 25 and 29 of the NDPS Act. Having heard the submission of learned advocates about the parties, it is provided that registry shall call for up-to-date status report along with the scanned copy of the record fixing the matter
On 23rd September
sorted. Next
and on 20 September.
20. 20.
Of the list items, item number 2. Item 2.
Sunday. None appears for the appellant on call or SSL is the matter after 1 week. It appears that on 3/9/2024 also the appellant remain absent. In the event of subsequent non-appearance, appropriate order shall follow. Is the matter after vacation.
On 29. Item number 3.
Please, Your Lordship, my lord, this matter may adjourn for the time being, my lord.
Time being,
Yes, my lord. After a short while, my lord.
both the parties are ready.
Yes, Lordship.
Promotion item 4.
May I appeal, Lordship? A second time bail application, my lord. Praying for second time, my lord, on the ground that my lord, co-accused, my lord, serial number 1 and 4, my lord. They were granted bail by the coordinated bench, my lord. Petitioner praying for bail on the ground of parity, my lord. Page 19 and my lord,
Heard,
page-
heard Mr. A.M. Ahmed,
Perusal of the case, that is they were granted, my lord. Now.
learned counsel for the applicant. And also heard Mr. K.K. Parasar, learned additional PP for the state respondent. This application under section 482, 482 of the BNSS 2023 is prepared by applicant Ramakrishna Soikia, who has been apprehending arrest in connection with Pampur PS case number 127 of 2023 under section 120B 420, 468, 471 IPC. Further, having heard the submission of learned advocates of both the parties, it is provided that Resisal no, Mr. Parasar learned additional PP shall produce the case there before this court on. Search it has not been submitted.
No, sir, no, down on 20, madam.
20.
Item number 6, matter for orders.
सीधा हासिल किया था इधर लोग आ गए this is the senior council. None appears for the appellant on call. Recessal is the matter after vacation.
Item 7,
Yeah, please. As per office note at 6-9, service report is awaited. Service report is awaited on respond number 1, 2, and 3, Lordship. And LCR also not received. Office note
Heard, Mr. Your good name?
A Burwa.
A
Burwa.
Borba, learned counsel for the appellant. Office note dated 6/9/2024 indicates that LCR has not been received and neither ID card nor answer notice issued to the respondent number 1, 2, and 3 is received by the section till date. It is provided that RESIS shall issue reminder to the learned district judge Surat for transmitting title suit probate number 1 of 2016 without further delay. RESIS shall raise the matter after 2 weeks awaiting service report upon respondent number 1 to 3. And RESIS shall also put up one up-to-date office note after taking the. You have taken step by registered post?
Yes, Lord.
Take the consignment and put up one up-to-date office note on next step.
So there's an IA in IA, there's an interim order in the IA. That request to be extended. Lordship.
The interim order passed earlier shall continue in IA number 2267 of 2024.
Obliged.
for hearing. Item number 8,
May it pleases your lordship, can be taken after some time.
items 9 and 10.
My lord, this matter may be taken after some time, my lord. My senior is on legs.
Who is your senior?
He is in court number 5.
Who is your senior?
PK Roy, for the appellant lordship,
The pattern matter.
after some time.
Item 11,
Obliged, lordship.
item 11,
You were in item 11? No. None appears for the appellant on call. Rest
I am
shall
for
be-
item number 11, respondent.
In RSA 224,
Yes, Lordship.
none appears for the appellant on call. However, Miss
S Toby,
Learned Counsel for the respondent number
all respondents, Lordship.
for the respondents present. List the matter after vacation.
Obliged, Lordship.
Item 12.
The concurrent finding, Lordship, this suit was dismissed, then appeal preferred, appeal was also dismissed. And the substantial question of law, basically, this is absolutely question of fact. So Lordship, kindly see the substantial question of law formulated page number 4.
You are for the respondent.
Yes, Lordship, this, I'm for the respondent, for all the respondents.
Who is for the appellant?
Appellant is the plaintiff, his suit was dismissed, Lordship. 12, yeah. His suit was dismissed. And thereafter, he preferred an appeal, appeal also got dismissed. There is basically no perversity of finding.
That's all right, but in that
No,
sense of
that is not
appellant,
there.
what can I do?
It's a old pending matter, Lordship, 2013.
I am ready to hear.
Yes, Lordship. Then after some time, Lordship, let me wait for
You were acquainted with the counsel for the appellant?
Lordship.
You were acquainted with the
Yes,
counsel?
yes,
for the-
I know him, Lordship. I'll communicate.
Inform him
Yes,
then.
yes. Lordship, in item number 8, this is a part hard matter. This matter, the appellant side is almost over. The last location, he has finished his part. In item number 8, if your Lordship pleases to take up this matter now. Item number 8.
Lordship, we will file the written argument. Item 8.
Lordship, this is also a concurrent finding of fact. The suit was filed by this respondent. The predecessor of the respondent with a prayer for declaration of right title interest and recover your possession. Now, here in this case, Lordship, these certain issues were framed. On the last occasion, when Learned Friend has emphasized on those issues. And the Learned Trial Court in the main suit framed the relevant issues with regard to the issue number 4 and 5. Issue number 4 is whether the Maleshwari, the predecessor of the interest of the defendant, purchased the suit land from Dharmeshwar Das, the predecessor of the interest of the plaintiff, is alleged by the defendant. Why the plaintiff has right title interest over the suit land. Now, with regard to issue number 4, Lordship, there was no counterclaim because here in this case, the defendant only filed the written statement. Thereafter, they did not adduce any evidence also. So now the suit which was filed by the plaintiff with regard to claiming her right title interest over the land, that was taken as a issue number 3 and issue number 4 with regard to the claim of the defendant. Now the claim of the defendant, because there was no counterclaim. So in that view of the matter, this claim of the defendant was considered, but that was in absence of any evidence, positive evidence in favor of the defendant, that was not taken into account. If your Lordship kindly see the issue number 4 and 5, the Learned Lower Court, Trial Court, page number 40. Page number 40, Lordship. The trial court judgment.
Yes.
Page number 40, Lordship, this issue number 4, with regard to the claim of the defendant that they had purchased the suit land, the Learned Trial Court came to a finding
issue number 4. For the sake of convenience, the issue is taken up ahead of the other issues. Now, before going into the facts of the decide the issue, the provision as envisaged under Indian Evidence Act under section 102 and 103 needs to be discussed. Both the sections speak in clear terms that the burden lies on the person to prove the particular facts, because here in this case, lordship, defendants had pleaded, although there was no evidence with regard to the fact that they had purchased the property. Now, the facts which he wishes the court to believe, the defendant took the plea that the predecessor interest had purchased the suit land from the predecessor interest of the plaintiffs. But there is absolutely no effort on the part of the defendants to prove the same through any document to show the purchase being made by the predecessor in preponderance of probabilities, which means that a party must prove his case by way of a relevant documents. The documents which are relevant for a party is given due weightage. However, the defendant in this suit failed to bring into record any document. There was absolutely no document, lordship, to show that the predecessor interest had purchased the suit land. In the absence of such proof, there remains no doubt that the defendants has failed to prove their case. So, with regard to their claim that they had purchased the suit land, that was demolished by the learned trial court on the basis that there was no evidence, because they did not adduce any evidence. Now, with regard to the right title interest of the plaintiff, lordship, the issue number 3 was discussed by the learned trial court. Issue number 3, the next issue, lordship, whether the plaintiff has right title interest over the suit land. Exhibit 2, 3, and 9 in the present suit clearly shows that the present plaintiff has title over the suit land. These are all revenue entries, lordship. Exhibit 9 being the relevant portion of the mutation copy shows in clear manner the name of the plaintiff is mutated in Dag number such and such, button number such and such. Exhibit 2 and 3 on the other hand shows the order of the court delivering the possession of the suit land to the present plaintiff in the year 1981. Now, this particular fact is relevant because, lordship, this previous to this particular suit, the plaintiff instituted a suit for declaration of their right title interest, and that suit was decreed, lordship. And after the decree was there, on the basis of the execution of the decree, the plaintiff took possession of the suit land. Subsequently, this is the contention in the plaintiff also, lordship. Subsequently, the defendant dispossessed the plaintiff with regard to a particular portion of the land, and accordingly, the suit was filed for declaration of right title interest, and this time for recovery of possession. Previous suit was only with regard to declaration of right title interest. Now, that is the reason why, lordship, the learned trial court came to a finding the two exhibit, this exhibit 2 and 3, on the other hand, shows the order of the court delivering the possession of the suit. This is pursuant to the execution of the decree to the present plaintiff in the year 1981. The exhibit clearly shows that the plaintiff has title and interest over the suit land. There is no dispute in regard to the fact that the possession of the land was conferred to the plaintiff by the court itself earlier. In view of the facts involved in the suit and that of the exhibits, there remains no doubt the plaintiff has a bona fide right over the claim she has made over the suit land and mentioned in the schedule of the claim. To add further, the plaintiff very fairly and in a sincere approach claimed 1/3 of the share in the total land consisting of 1 vika 2 kata 16 lecha, which stands at 2 kata 12 lechas of land as mentioned above. The title of the plaintiff is very much explicit over the claims being made on the respective share of land. So, because of the revenue entry and because of the two documents which were exhibited pursuant to the execution of the decree, the plaintiff had been able to prove that there was the possession was duly handed over to them, and that aspect of the matter not being rebutted by the defendant by adducing any cogent evidence or demolished by way of a cross-examination. Now, with regard to the issue number 5, whether the plaintiffs are entitled to a decree as paid for, then the learned trial court came to a finding that as decided in the foregoing issues, there remains little doubt that the plaintiffs have genuine claim and title over the suit land at hand. In view of such a position in the suit, the plaintiffs are entitled to a decree as paid for in the instant suit. So, accordingly, the decree was the judgment decree was there in favor of the plaintiff. Now, the present appellants challenge that particular judgment and decree before the lower appellate court. Now, the learned lower appellate court dismissed that particular appeal. Now, this appeal starts from, lordship, page number 31. Page number 51, lordship. Page number 51. Now, the issues which were settled by the learned trial court that were discussed, page number 51, lordship. The issues are at page number 54. Page number 54, lordship. Lordship got it? Now, in here in this particular appeal, Lordship, the learned lower appellate court with regard to the issue number 3 and 4, whether the plaintiff has right title interest and whether the full assured the predecessor interest of the defendant purchase the suit land, came to a finding, Lordship. The finding is at page number 57, Lordship. 58. Issue number 3 and 4 joined together, and accordingly that was discussed by the learned lower appellate court. Now, here in this case, if your Lordship kindly see page number 58. In my considered opinion, I find that the issue number 3 and 4 are interlinked. Plaintiff claimed right title interest in respect of 2 kata 12 acres of land. Defendant took the plea that the plaintiff ancestors sold 2 katas of land to their ancestor, namely Fuleshwari. Therefore, if defendant is successful to establish the fact that the plaintiff ancestor sold out 2 katas of land in favor of their ancestor, then the plaintiff would not have right title interest in respect of 2 katas of land. Under such circumstances, they have only right title over 12 acres of land. In view of that matter, issue number 3 and 4 are interlinked with one another. Defendant, though in their written statement, took the plea that on 2354 by registered deed number such and such Dharmeshwar, the ancestor of the plaintiff in need of money, sold land measuring 2 kata in favor of the ancestor of answering to interesting defendant number 1 and 3. But along with the written statement, defendants have not submitted the said registered deed. That was never been submitted, Lordships. Further, defendant written statement does not show description of 2 katas of land which they alleged that their ancestors of the defendant number 1 and 3 purchased. On meticulous scrutiny of the record, I do not find any copies of the sale deed as alleged by the defendant on record. When defendant took the plea that ancestor of the plaintiff transferred the suit in favor of the Fuleshwar Koibortani, the ancestor of the defendant number 1 and 3, it is their duty to establish and prove the execution of the sale deed by the ancestors of the plaintiff in favor of ancestors of the defendant, while defendant miserably failed. When defendant failed to prove the transfer of the land in favor of the ancestor of defendant number 1 and 3, namely Fuleshwari Koibortani, they have got no right to execute any deed in respect of the suit land in favor of any third party. When defendant failed to establish their saleable right in respect of 2 katas of the land, their transfer of 13 acres of land out of these 2 katas of land in favor of defendant number 5 is void, and I find the defendant failed to establish the issue number 4 in their favor. PW3 in her evidence stated that the suit land originally belonged to her father. Plaintiff witness denied the transfer of the suit land in favor of the Fuleshwari Koibortani by Dhaneshwari Das. Exhibit 4, the Jamamundi copy of the suit patta of such and such settlement period, it shows that name of Dhaneshwar Das mutated along with other pattadar by right of purchase. Patta also shows that there is one Dhaneshwar Koibortani and one Dhaneshwar Das shown as pattadar in the suit patta land. A name of Dhaneshwar mutated in the suit patta by right of purchase as per Exhibit 4 on 29/8/1963 by mutation case number such and such. Thus, this Dhaneshwar sold land in the year 1944 does not carry any strength and force. Defendant admitted that the suit land belonged to Dhaneshwar Das, the ancestor of the plaintiff, and therefore, as per the right of inheritance and transfer of land measuring such and such is proved, I find that the plaintiff has got right title interest in respect of the suit land by right of inheritance, and issue is decided. So, we are basically, the plaintiffs are basically claiming the right title interest on the strength of their inheritance. Now, by exhibiting certain documents, Lordship, exhibit number 19, exhibit number 2 and 3, the plaintiffs have been able to establish their absolute right over the property. So, in that view of the matter, Lordship, the learned trial court dismissed they allowed the suit and decreed the suit, and accordingly, when the appeal was preferred by the defendant, that was dismissed. Now, on 21/8/2024, Lordship, the substantial question of law was formulated. Two additional substantial question of law was formulated, Lordship. Now, the first, with regard to the fact that whether the learned courts below were justified in decreeing the suit in favor of the plaintiff in absence of any document of title being exhibited in accordance with the law. So, this particular substantial question of law was formulated. Now, with regard to this aspect of the matter, Lordship, I'm just intending to rely on one judgment of the Honorable this Guwahati High Court. Guwahati High Court, Lordship. In this case, Lordship, this is of 1998 4 GLT 137, Lordship. I'm just provide the copy. In this particular judgment, Lordship, it was the observation was that, Lordship. I'm just reading the relevant paragraph. Paragraph number 9, Lordship. Paragraph number 9, Lordship, under the Assam Land Revenue Regulation, a person who is a patta holder is deemed to be a landholder and he has a permanent, heritable and transferable right of use and occupancy in his land, subject to section 9 of the Assam Land Revenue Regulation. And if a person, in order to establish his title, produces a patta, that must be given due weightage in as much as the patta is issued in accordance with the provision of section 17 deal with the rules, and that must be considered to be a document of title. And this is paragraph number 9, Lordship. 20 to 50. Yes. Must you got it? Paragraph number 9. Further, the record of rights as provided under section 40 and 41 of the Assam Land Revenue Regulation shall always be deemed to be the correct unless the contrary is proved, and that presumption which is attached to the records of right under section 40 and 41 must be given due weightage, and that is what was done by the learned Lower Appellate Court. Regarding mutation entries, it can be said that though the mutation entries may not be the basis of title, yet the mutation entries cannot be brushed aside, and it must be received due consideration at the hand of the court. Of course, it must be ascertained that the mutation entries were duly were done properly. It is found that the mutation entries were not done properly, and or if it is collusive and fraudulent, that mutation entries will not create any right. Now, here in this case, Lordship, mutation entries, because the observation of the Honorable High Court with regard to the mutation entries is that presumption which is attached to the record of right under section 40 and 41 must be given due weightage, and that is what was done by the learned Lower Appellate Court. Here in this case, Lordship, there is no presumption or there is no better title establishing or demolishing the claim of the plaintiff in any manner, Lordship, because they could not produce the sale deed. There was no document to show that they had purchased, their predecessor had purchased the property. And the learned Lower Appellate Court and as well as the learned Trial Court duly came to a finding that this particular aspect of the matter, there is no evidence, because when they adduce the evidence or at the time of written statement also, Lordship, they did not need any document or they did not exhibit any document with regard to the fact that they had purchased. So in that view of the matter, Lordship, this particular substantial question of law would not come in the way of the way of the plaintiff to establish the fact that they have no right title interest over the suit land. And with regard to the second substantial question of law, Lordship, that whether the findings arrived at by the learned Trial Court that the plaintiff has right title interest, whereas the suit property suffers from perversity in view of the evidence on record. Evidence is very much there, Lordship. This evidence, the witness number 4, the PW4, in his evidence specifically mentioned. Your Lordship, can you see the evidence of PW4? Got it.
Yes, at page number.
Page number, Lordship, this 26. Page number 26. He is the junior assistant records keeper.
Page number 26 and this appeal is the written statement.
It is not in the appeal memo, Lordship.
Where?
This is a typed copy of the evidence, Lordship.
Where it is available?
Lordship, this.
I don't know. It's a written agreement.
Lordship got it? No, where? There's a PW4, I think. Can I check the record? Lordship? Yes. I'll give a flag mark, Lordship. Let me read over this particular evidence. PW4.
Yellow color.
Yes, Lordship.
Yes.
PW4, Lordship. I have received summons and appeared on with relevant documents from the draft Jamabandi such and such, but the old age number such and renumerated patta number such and such. The area of land was 1 biga 2 kara 10 lecha. The pattada Dhaneshwar Koiborto and Someshwar Koiborto represented by a mother, Jyoti wife of Hanina Jyoki Koiborto, Hiram Nemeti Koiborto, and the 5 and 6 number pattadas were newly included in the settlement. I have also produced the 1968-69 draft chita. In this chita, old dag number such and such was converted to dag number 674. The old patta 357 got converted to patta number 394. The area remained 1 biga 2 kata 16 leches as before in place of Dhaneshwar and Jyoti. Their successor Maleshwari Das, wife of Dhaneshwar Das, name got newly inserted in the record. Exhibit 9 is the certified copy of the draft chita issued by the office, and Exhibit 9 was the signature of Upendranath Bora, then revenue. So the name of the predecessor of the plaintiff has been reflected in the Jamabandi copy that has been proved by the concerned this junior assistant record keeper by way of this PW4, and there was no cross-examination with regard to that. So in that aspect of the matter, Lordship, this evidence establishing the title of the plaintiff was duly proved by the concerned authority from the Revenue Department, Lordship. So in that view of the matter, Lordship, the learned trial court as well as the lower appellate court arrived at a definite finding or conclusive finding with regard to the right title interest of the plaintiffs over the suit land. Now, this particular issue with regard to the issue number 2, substantial question number 2, Lordship, with regard to the right title interest has been duly taken care of by the courts below, Lordship, and there is no scope for interference and there is no perversity of the finding. In this regard, Lordship, I want to rely on judgment of the Honorable Apex Court. This is 2020, Lordship, 19 SCC. 2020. 2020, 19 SCC, Lordship. I'm just referring to one particular paragraph with regard to the with regard to the fact that when there is a concurrent finding of fact, Lordship, the scope of the Honorable High Court to interfere is very limited. Now, here in this case, the Honorable Apex Court came to a finding at paragraph number 36, Lordship. In a second appeal, Lordship, got it. Paragraph number 36. In a second appeal, the jurisdiction of the High Court being confined to substantial question of law, a finding of fact is not open to challenge in second appeal, even if the appreciation of evidence is palpably erroneous and the finding of the fact incorrect as held in such and such. An entirely new point raised for the first time before the High Court is not a question involved in the case unless it goes to the root of the matter. So here in this case, Lordship, with regard to the fact, with regard to the substantial question of law, that any document of title was not there, it is not the case of the defendant at any point of time. Only by way of this written statement, they had claimed their right over the property on the strength of some sale and purchase. But with regard to that, there was no evidence. So that aspect of the matter has been covered by the Honorable Apex Court by this particular judgment in paragraph 36. That even if there is a appreciation of evidence is erroneous, then also when there is a concurrent finding of fact, the High Court, the jurisdiction of High Court is very limited with regard to that. So my humble submission, Lordship, there is a scope is very limited, and since there is no perversity of finding with regard to the factual aspect of the matter, the second appeal is otherwise not maintainable, because whatever issue or substantial question of law has been formulated, these are all substantial question of fact. There is nothing law involved in the formulation of the substantial question of law. Another point was raised, Lordship, in the substantial question of law at the time of admission of the second appeal, was with regard to the fact that this is there is the previous suit The previous suit is there and subsequently whether the subsequent suit can be can be taken into account by the learned trial court, whether it is maintainable or not. When the previous suit, the decree was there and thereafter that particular decree was set aside by the lower appellate court, remanded back to the trial court for fresh decision, and that suit was dismissed. And subsequent to that, another suit was filed, and this present suit with regard to which the appeal is pending, that suit was preferred by the plaintiff without restoration of the original suit. That was the substantial question of law formulated at the time of admission. Now, with regard to that aspect of the matter, lordship, the first suit was with regard to the declaration of rightly interest. There was no specific prayer for recovery of possession. But in the subsequent suit, lordship, new cause of action arises when the defendant entered into possession of the suit land by evicting the plaintiff. So this particular suit, which has been subsequently filed by the plaintiff, this is absolutely on a new cause of action, lordship. It has nothing to do with the previous suit. And whatever document was adduced by the plaintiff, based on that, title was duly proved by the plaintiff. So in that view of the matter, lordship, that substantial question of law also cannot be taken into account by this honorable court, lordship, because this second suit that has been preferred, this is absolutely based on new cause of action after the possession was taken by the defendant by evicting the plaintiffs. So in that view of the matter, lordship, this second appeal is otherwise not maintainable because the question of law is not there. These are all question of fact. There have been the defendants or the appellants herein have been failed to establish their right in any manner because there was no evidence, no documentary proof to establish their right. Lordship.
So earlier there was only one substantial question of law.
Exactly, lordship, and with regard to that, lordship, just since the previous suit was dismissed for default, whether by not restoring that one, the subsequent suit, whether it is maintainable or not. So this particular subsequent suit was with regard to a defined cause of action, lordship, and that is the reason why on the last occasion, on 21/8/2024, two additional substantial question of law was formulated, lordship, with regard to the mutation entry. Now, the mutation entry just now I've given a judgment of this honorable court, and that was challenged before the honorable apex court also, lordship. I'm just giving that judgment also, 2011 4 SCC, lordship. The appeal was also dismissed. This 2011 lordship, 4 SCC 801, lordship. And the High Court dismissed the appeal, then they preferred, the other side preferred the appeal, SLP, before the honorable apex court, and that was also dismissed, lordship, on the same ground.
Where is the judgment?
I just given, lordship. This is a 2011 lordship, 4 SCC, already given. 2011 4 SCC, lordship.
Continue. So this judgment relates to
lordship, this particular with regard to the mutation entry, lordship, because the point that has been raised that whether the mutation entry, because there is no substantial question of law which was formulated on 21/8/2024 with regard to the fact that the learned court below were justified in declaring the suit in favor of the plaintiff in absence of any document of title. Since there was no document of title, we relied on the mutation entry, lordship. The point that was raised, lordship, in the second appeal, that there was no title document exhibited or the adduced by the plaintiffs in deciding or in establishing their title over the land. So I'm just relying on this particular judgment to show that when the mutation entry is there and there is no contrary evidence challenging or this particular aspect of the matter, then the mutation entry may be presumed to be correct, Lordship. That judgment was by the Honorable High Court, and that went to the Supreme Court also, but Supreme Court upheld the same findings, Lordship. And the other judgment with regard to the concurrent finding of fact, Lordship. And there is the concurrent finding of fact under section 100, the scope is very limited, Lordship.
Yes, any reply?
I guess counsel is in Kolkata due to some personal problem. So kindly a date may be given so that he could submit his counter submissions.
Pardon?
Could submit his for counter submissions, so a date may be given, my lord.
Also, on the last occasion, he completed his submission.
Yes, my lord, we have
And it was
already
supposed to
submitted
today,
to-
he was supposed to file the written argument. So Lordship may fix a date for judgment. In the meantime, I will also submit my written argument. My learned friend also can submit the written argument.
No, he had already submitted.
Yes,
written
Lordship.
argument.
He has already finished his.
No, is there any point?
First thing is that the exhibit 2 and 3, which the learned lower court has relied, it's already set aside by the lower appellate court in the year 2000, in the year 1981. And regarding the revenue and the mutation entries, in Supreme Court in Suresh Bhan case, it is a well settled that an entry in revenue records does not confer title on a person whose name appears in the record of rights. It's a settled law that entries in the revenue records of Jamabandi have only fiscal purpose and payment of land revenue. No ownership is conferred on the basis of such entries. This is held in 2007, 6 SSC 1986. We have submitted the judgment in our written statement, my lord.
2007?
2007, 6 SSC 18/6, 186. Moreover, my lord, in their exhibits, that is in exhibit number 6, Kuleshwari Koibota, the predecessor of the defendant's name, is there as a pattadar. And it is also confirmed by the PW4, who is the junior assistant record keeper of district magistrate, Nagaon. He deposed that I have received summons and appear with the relevant records from the draft Jamabandi of 1957-58. It appears that Miyaji Patta number 255 is Srinagar and so and so, the old duck number is 11 so and so. The area remain 1 biga 2 kata 16 lessons. The pattadars, number 1 is Dharmeshwar Koibotro, number 2 is Someshwar Koibotro, minor represented by her mother. Number 3 is Jetuki Koibotro, number 4 is Nimati Koibotro, number 5 is Lutfur Rahman, and number 6 is Fuleshwari Koibotro, the predecessor in interest of the defendants, that is the appellants. Her name is there as a pattadar in their exhibit, which they have submitted. And it was also confirmed by PW4. He also further deposed that the 5 and 6 number pattadars were newly included in the settlement. This Jamabandi is of the year 1957-58. Our contention is that in the year 1954, Fuleshwari Koibotro has purchased the land. And it is in their exhibits that her name was there in the pattadar in Jamabandi, 1957-58. And again, one thing is that, my lord, the plaintiff filed a suit for 2 kotha 12 acres. But in the decree, the court has allowed, the learned lower court has allowed 2 kotha 16 acres of land. 4 kathas, 4 acres more land to them. But they have only filed a suit for 2 kathas 12 acres of land. That is one thing, my lord. And regarding the suit length, the PW2 in her cross-examination deposed that I have filed this case against 2 kathas 12 acres of land I do not remember the boundaries of the land. I do not remember the Dag number, Pata number. And I do not know the previous owner's name. That the PW3 in a crossing also deposed that the suit land measures took as well as I do not know the boundary of the suit land. I never visited the suit land. So she has deposed such thing in the cross examination. And she also said that it is a fact that in the plaint I have shown that on the south side, on the south of the suit land, there is a land of fullest Vitas. She has named our predecessor in interest. My lord, in this Honorable High Court Imphal bench in R.K. Madhurjajit and another versus Takilabam Abung Singh, Civil First Appeal number 5 of 1998, has held that in paragraph number 15.
No, on the other day, Mr. Gogoi has argued on this point.
Yes, my lord, he has already he has submitted this.
Yes. You cannot repeat it again.
Okay, my lord. It has been written on our
Okay.
written document.
Heard, Mr. Your good name.
C. Sharma.
Learned counsel for the appellant and Mr. S.P. Sodore, learned counsel for the respondent. Argument concluded, judgment reserved.
Actually, written argument is required. Written argument is required to be submitted. Written argument.
Up to you.
Not required. Then I will rely another judgment lordship is not. It will be kept on record lordship.
Item number 13.
Hello, bless.
Item 13.
My schedule is personal difficulty, so matter kindly action for the day lordship. Fix for next week lordship.
Mr. Your good name.
And Borwa lordship.
Learned counsel appearing on behalf of Miss
Appealing lordship. MD Sodore.
Mrs. M.D. Sodore, learned counsel for the appellant, submits that his senior has some personal difficulties and as such the matter may be adjourned for the day. Here allowed, recess shall list the matter after vacation.
Item number 14.
Lordship will take up the matter after some time. My senior is coming, Lordship, Mr. G. N. Sehgal. Just call him, Lordship.
It may be adjourned, my lord, today. Today may be adjourned, my lord.
Pardon?
Maybe adjourned today.
Why?
Because, my lord, for the time being when.
Lordship, he's just, I have just called him, he's coming, Lordship.
Wait for some time.
Obliged.
Timing and 12. My lord, and preferred against my lord, the judgment and decree dated my lord, 31/10/2008 and 11/2011. 31/10/2000. Sorry, my lord, judgment and order decree dated 2/4/2013, my lord, entitled appeal number 35 of 2028. My lord, while admitting the appeal, lordship, two substantial question was raised. First is that, my lord, whether, my lord, plaintiff number was inheriting the suit of the tenancy right of his predecessor Jalandhar Rai is evident from the evidence of landlord defendant number 3. And in that view of the matter, both the court below committed illegality in holding that Nirod Rai is not the adopted son of the Jalandhar Rai. Second is that, my lord, or the finding of the court below is perverse in the face of the evidence of DWP. Now, my lord, is in a nutshell is this, my lord. Actually, the original owner of the suit land was someone Indeshwar Mohanto and the Jalandhar Mohanto, my lord. In the year 1976-77, my lord, the sale was put to a revenue sale, my lord, because for non-payment of land revenue, my lord. And virtue of that sale, my lord, Girish Namashudra, my lord, who is the predecessor of the here defendant, my lord, in the title suit, my lord, defendant number 227, my lord, they purchased that suit by virtue of a sale certificate granted in that my auction sale, my lord. In that, my lord, when that suit land was purchased by Girish Namashudra, my lord, at that relevant time, Jalandhar Roy, my lord, the predecessor of the plaintiff number 1, that means the appellant 1 here, my lord, they have been possessing the land as an occupancy tenant, my lord, as defined under the Assam temporary settled areas tenancy act of 1971, my lord. And that has been continuing, my lord. And my lord, occupancy tenants is the long back, original owner after purchase of Girish Chandra Namashudra is allowed to cultivate, my lord, even under the Girish Namashudra as an occupancy tenant, my lord. Now, my lord, that Jalandhar Rai was an occupancy tenant under the Girish Namashudra, my lord. He had no son and daughter of his own, my lord. This couple, that couple, my lord. So they brought his Nipu, my lord, Nirod Rai, who is the, my lord, the appellant number, my lord, appellant number. Who is the, my lord, the plaintiff number 1 in the title suit, my lord. He was brought up by them, my lord, and deciding with them, my lord. Since the couple has no issue at all, my lord, that my lord will find it page 7 of the appeal memo, para 4 of the plaintiff, my lord. Page 7 of the appeal memo, my lord, para 4 of the pleading.
Yes.
Then, my lord, the eventually, my lord, the Jalandhar Rai died, and both the couple died, my lord, one after another, my lord. And then but the plaintiff continues to possess the land, my lord, as an occupancy tenant, my lord, even under the, my lord, the Girish Namashudra in his legal hearsay, without any objection, lordship. Then in the year 1994, that my lord will find with page 8, para 6, 1994, plaintiff sold the jot right, my lord. That plaintiff, my lord, Nirod Roy, sell his jot right, my lord, because he is a occupancy tenant. So his jot right, meaning thereby my lord, tenancy right, in favor of my lord, the plaintiff number 1, that is my lord, the Nirod Roy. Nine. Nirod Rai on a valuable consideration of 20,000 by executing an unregistered Swarnolipi, my lord. And this unregistered Swarnolipi, my lord, has been exhibited, and my lord, probate exhibit, my lord, exhibit 4. Exhibit 4, my lord. Then, my lord, after transfer of the jot right by the plaintiff to the plaintiff number 2, Siroshik Rai, elder son of the Girish Namashudra, also acknowledge the above of the said purchase by plaintiff 2 by executing Swarnolipi on 19/10/1994, and the yearly rent of the said land was fixed as 560 per year. And the defendant number 2 was fully aware of the above Swarnolipi dated 19/10/1994. Then, my lord, after defendant number 1, the defendant number 1, my lord, is my lord, the Sunamoni Roy. Defendant number 1, my lord, in collusion with my lord, defendant number 2. Defendant number 2 is Amala Roy. Who is the daughter of the, my lord, Girish Namashudra, my lord. They, my lord, instituted a title suit, my lord, in 125 of 94, my lord, against the defendant number 2 for specific performance of the contract. That means, my lord, the Monir, it is meaning thereby, my lord, Monira made an agreement, executed an agreement of sale with the, my lord, Amala Roy to purchase the said land, my lord. Since the, my lord, the agreement was not, it was not complied with, therefore, a passive suit for passive impertinence was preferred, my lord. By the defendant number, my lord, 1 against the defendant number 2, Amala Roy, with the legal heirs and the daughter of the Girish Nomashudra, my lord. So, it was decreed, my lord. So when we came to know about that, my lord, so thereby, my lord, declouding our tenancy right over the suit land, my lord, this present suit was filed. Now, my lord, I will take your lordship to the, my lord, straightway to, my lord, the judgment of the trial court, my lord. Lordship will find it will, lordship can look into, my lord, page 32, my lord. That is the lordship will find. May I read, lordship? Start from page 33, lordship. The trial court judgment. Because the suit was previously decreed in my favor, then they preferred, the defendant preferred an appeal. In the appeal, as 2 new additional issues was framed, then what was remanded to the trial court for deciding that issue. That is why I'm just going through the, my lord, the judgment of the trial court. We start from page 33, lordship. The suit is for the declaration and confirmation of the jute right. The plaintiff case in an appeal is there. The original owner of the suit land was Indeshwar Mohanto and Jaladhar Mohanto. In the year 1976-77, Girish Nomashudra, the predecessor of defendant number 227, purchased the suit land. At the time of the said purchase, Jaladhar Roy, predecessor of the plaintiff number 1, was possessing the suit land as an occupancy tenant since long back under the original owner, and the purchase by Girish Nomashudra, he is also acknowledged the tenancy right of Jaladhar Roy. The Jaladhar Roy has no issue, and he bought his nephew Nirod Roy, the plaintiff number 1, to his home and began to live together. Jaladhar Roy died, leaving behind his wife Chintamani Roy and the plaintiff number 1. Subsequently, Chintamani Roy also died in the year 1984, leaving behind the plaintiff number 1. And since then, the plaintiff number 1 possessing the suit land without any objection. That in the year 1994, plaintiff number 1 sold out the jute right of the suit land to plaintiff number 2 on a valuable consideration of rupees 20,000 by executing an unregistered Swarnalipi dated 4/3/1994 and delivered possession to him. That after the transfer of jute right by the plaintiff number 1 to plaintiff number 2, the defendant number 3, the elder son of the Girish Nomashudra, is also acknowledged the purchase by plaintiff number 2 by executing a Swarnalipi on 19/10/1994. That the defendant number 1 in collusion with the defendant number 2 filed title sheet number so and so in the court of edition number 1 Silchar against the defendant number 2 for specific purposes of the contract. The defendant number 2 did not file any written statement on that suit was decreed ex parte on 2/4/1995. The boundary given in the title TS number so and so include the homestead and the agricultural land of the plaintiff number 2. The defendant number 1 and 2 collusively filed the TS number so and so to dispossess the plaintiff number 2 from the suit land. The defendant number 1 and 2 fraudulently obtained the decree and TS number so and so. The plaintiff came to know about the fraudulent decree from the neighbors to whom the defendant number 1 sold his intention. The fraudulent decree gives rise of cause of action to the plaintiff, accordingly find the present suit for declaration of the jute right and the confirmation of possession and other reliefs. The defendant number 1 presented the written statement denying all the allegation of the plaintiff. The defendant denied that the plaintiff's statement that Jalandhar Rai had no issue and he brought the nephew, the plaintiff number 1, to his home and began to live together with. The defendant submitted that the suit land was paternal property of the defendant number 2, and he, for want of money, agreed to sell the land to the defendant number 1 and also executed contract for sale. Subsequently, the defendant number 1 obtained decree and TS number 125 of 1994. The decree is not a fraudulent
decree, the defendant accordingly paid for dismissal of the suit with cost. On pleading, certain issues were framed and the trial starts. During the trial, the plaintiffs have reduced 4 witnesses and defendants have reduced 3 witnesses. After the trial, argument was heard and judgment delivered. The suit was decreed on contest. That is on my lord, that is original. The suit was decreed on contest with the cost, declaring plaintiff are non-evictable tenants. Under the landlord of the defendant number 227, the confirmation of possession was also declared in favor of the plaintiff. The injunction is paid for is granted. It is also declared that plaintiff are not entitled for the relief issuing direction to the collector to issue quotidian in name of the plaintiff. So that is my lord, when they filed this title suit, my lord, against the defendants, my lord, that was the original findings of the my lord, the judgment of the trial court, honorable trial court, my lord, against which the defendant number preferred an appeal. The next paragraph, my lord, you'll find on being encrypted by the decree, the defendant approached the appellate court by instituting the appeal number TA of so and so. The honorable appellate court held that the proper issue were not framed in the suit, and honorable court framed 2 new issues. The decree was set aside and the suit was remanded back to the original court to decide afresh after framing 2 new issues. The court record received the fresh issue. The 2 new issues are framed as per direction appellate court issue, including 2 new issues as follows. So, my lord, these were the original issue first, my lord. Now, the new issues, my lord, which was framed as per framed by the appellate court and remanded back to the my lord trial court for decision. That my lord will find it issue number 7 and 8. Whether the plaintiff number 1 got social and legal recognition to claim the right over the property enjoyed by Jaladhar Rai and his wife Chintamani Rai, and thus acquire any right, transfer right over the property of late Jaladhar Rai and Chintamani Rai. Whether the defendant to collusively enter into an agreement for sale of plot of land to defendant number 1, and whether defendant number 1 collusively filed TS number so and so obtain a fraudulent decree in respect of the suit land. After framing the issue, the above 2 new issue, both the sides were given opportunity to adduce further evidence on the bar. Plaintiff failed to adduce any evidence in spite of several given to them. The defendant have not turned up to adduce further evidence or to submit their law points as newly framed 2 issues. Now, my lord, issue number 7 and 8. Lordship, the court has discussed, as the issue is more vital for the disposal of the suit, to this issue is taken for the first for discussion. The plaintiff number 1 submitted that the original owner of the suit land was Industrial Mahanto and Jaladhar Mahanto. In the year 1976-77, Girish Namar Figro, the predecessor of the defendant number 1 to 7, purchased the suit land. At the time of the said purchase, Jalandhar Rai, predecessor of plaintiff number 1, was possessing the suit land as an occupancy tenant since long back under the original owner, and after the purchase by Girish Namar Shudra, he also acknowledged the tenancy right of the Jaladhar Rai. The Jaladhar Rai has no issue, and he has brought his Nipur Nirod Roy, plaintiff number 1, to his home and began to live together. Jaladhar Rai died, leaving behind his wife Chintamani Roy, and plaintiff number 1. Subsequently, Chintamani Roy also died in the year 1984, leaving behind the plaintiff number 1. And since then, plaintiff number 1 possessing the suit land without any objection. First of all, the plaintiff number 1 failed to lay any evidence Jalandhar Rai was an occupancy tenant under the owner Indeshwar Rai, Mahanto and Jaladhar Mahanto. If suppose it is presumed that Jaladhar Rai was occupancy tenant, then the question arises to whether plaintiff has the right to claim about the property. Plaintiff number 1 stated that he is a nephew of the Jalandhar Rai. The burden on the plaintiff to prove relationship uncle nephew between the Jaladhar and him. The plaintiff number 1 appeared as PW1. He is reposing his chief that my father Jaladhar Rai had no issue, and that is why he brought me in his wealth and reared me up. PW3 in his chief reposed that plaintiff number 1. My lord, that is very important because PW3 deposition, my lord, though it is mentioned here, but it was not taken into consideration by the trial court, my lord, while deciding the whole issue, both the court, entire issue. That I will come later, my lord. I'll just go through that evidence also, my lord. PW2 in his chief deposed that the plaintiff number is the nephew of the Jaladhar Rai. In the plaintiff claimed that he is the nephew of the Jaladhar Rai, but in his deposition he stated he was bought by Jaladhar Rai, my lord. So that's this is not too late, my lord. The trial court, lordship, but the plaintiff failed to prove the plaintiff failed to prove that he was really adopted by the Jalandhar. None of the plaintiff witness deposed in this line. The adoption must be recognized by the society. In the past, adoption was viewed primarily as a mean for a childless married couple to normalize their relationship. The plaintiff must show that at what age and how he was adopted. Moreover, the plaintiff was not specifically pressed in specific term that he was actually adopted by the Jalandhar Rai. Mere living with a person does not create a status of adopted son. Adoption ordinarily terminate the right and responsibility of the natural parents to the child. It is not mentioned by the plaintiff as to who are his natural guardian or wherever them. In light of the above minor discussion, I therefore opine that plaintiff number 1 has got no social and legal recognition to claim the right over the property enjoyed by the Jalandhar Rai and his wife, late Chintamani Rai, on the mere fact that he was backed by Jalandhar Rai, and therefore plaintiff number 1 has not acquired any right to transfer over the property of late Jalandhar and Chintamani Rai. The issues are negative and, my lord, in against the plaintiff, my lord. Now, my lord will issue number 1. That, my lord, in a law, a cause of action is a set of facts sufficient to justify the issue number 1 was that, my lord, whether there is any cause of action for this suit. I'll also in a law, if a cause of action is set of the facts sufficient to justify a right to issue, the phrase may refer to legal theory upon which a plaintiff brings suit to pursue cause of action. A plaintiff pleads or alleges facts in a complaint, the pleading that initiates a lawsuit. A cause of action generally encompasses both the legal theory and the remedy. Therefore, the cause of action must contain both allegation and the remedy. Plaintiff in a plaint submitted that the cause of action arose on plaintiff when he came to know about the fraudulent decree on dated 2/4/1995 passed in title suit number so and so from the neighbor as to whom the defendant number 1 sold his intention. There is no relief sought by the plaintiff that the title is the fraudulent decree and decree is liable to be set aside. The plaintiff themselves stated that the boundary gives in a TS number so and so includes the homestead and agricultural land, and the plaintiff number 2. Therefore, until the decree is declared fraudulent and set aside, it has binding force, and the plaintiff are still bound by the decree. The relief claimed by the plaintiff are not related to the validity of decree of TS number so and so. In light of the above discussion, I find that although there is an allegation by the plaintiff in the decree is fraudulent, but they have not paid for relief in the suit to declare the decree as a fraudulent and liable to be set aside. Therefore, I open that there is no cause of action for the suit, and the suit is answered in negative against the plaintiff, my lord. Now, issue number 8. Issue number 8, my lord, whether the defendant number 1 collusively enter into an agreement for sale of a plot of land to defendant number 1, whether defendant number 1 collusively file title suit number so and so to obtain a fraudulent decree in respect of the suit land. Now, plaintiff in the plaint stated that the decree passed in the title suit number 125 of 1994 is a fraudulent decree, but the basis as to how the decree is fraudulent is not mentioned by the plaintiff. PW1 in cross-examination replied that he do not know if there is any agreement between the defendant number 1 and 2 regarding the sale of the suit land. PW2 replied that he do not know anything regarding TS number 25 of 1994. PS4 deposed nothing regarding TS number so and so. The burden of proof that the decree is fraudulent upon the plaintiff, but the plaintiff could not lay any satisfactory evidence to show that the decree is a fraudulent one. Plaintiff number 1 himself do not regarding any agreement between defendant number 1 and 2. Other independent witnesses also ignorant are also ignorant about the titles number so and so. Therefore, plaintiff are totally failed to establish that the agreement and the decree passed in 125 of 1994 is a fraudulent decree. The issue is answered in negative. and against the plaintiff. So my lord, basically these are the two issues, my lord. And these issues were, my lord, when we preferred an appeal before the first appellate court, the issues was, my lord, confirmed by the first appellate court, my lord. Against that, my lord, we preferred a second appeal and due to substantial question of law. My lord, the first question is this, my lord, with regarding the, my lord, status of a occupancy tenant. Now, who is the occupancy tenant? Now, who is the occupancy tenant? What are the right and liabilities of occupancy tenant? My lord, it is governed by, my lord, the Assam Temporary Settled Areas Tenancy Act of 1971, my lord. Then it is a hereditary right, my lord. Suppose, my lord, I am a occupancy tenant under a landlord, my lord. My son, my adopted son, whatever it is, they, by virtue of that, they also become a occupancy tenant, my lord, under the original landlord, my lord. Now, that, my lord, I'll take my lord to Assam Temporarily Settled Areas Tenancy Act, my lord, 1971. Huh?
Okay, we'll resume after 5 minutes. In the meantime, he will collect the book.
My lord,
It
I
is
am
not
sorry,
available
Lordship.
with us.
I told my, they should have supplied a list of books, my lord. I am sorry, Lordship.
Okay, no problem. We will collect it from the library.
My lord.
We will resume after 5. Yes.
Yes. So. Now, my lord, if you look, Lordship, look into chapter 2 of the same act. Lordship will find section 4. Classes of
Section?
10, chapter 2 of the Assam Temporary Settled Areas Tenancy Act, my lord, section 4. We'll go to section 4, my lord. The classes of tenants, Lordship is got, my lord. Section 4.
Yes.
My lord, there shall be for the purpose of act only following classes of tenants, namely 1, occupancy tenants. That is to say, a tenant holding immediately under a proprietor, landholder, or settlement holder, other than the landholder, having a right of occupancy in the land held by him. And the 2 is, my lord, non-occupancy tenant. That is to say, a tenant holding immediately under the proprietor, landholder, or settlement holder, other than landholder, but not having the right of occupancy in the land held by him. So the basic difference is that, my lord, occupancy tenant is having the right of, my lord, right of occupancy in the land held by him, which, my lord, the non-occupancy tenant does not have, lordship. My lord. Now, lordship will find section 5, my lord. Acquisition of occupancy rights. How it is to be acquired. Section 5. A person who is for the period of not less than 3 years has continuously held as a tenant shall have a right of occupancy in that land. The period of 3 years may be wholly or partly before or after the commencement of the act. A person shall be deemed for the purpose of this section to have continuously held the land under a landlord, notwithstanding that a particular landlord under whom he held the land was at different times, provided the land is held by him was the same. Here, my lord, before its purchase by the Girish Namasutra, my father, my lord, who adopted me, my lord, my uncle, he was holding the land under the original. After the purchase, he was also holding the land. And after demise of them, this revolved on me, my lord. By virtue of section 3. Section 5. A tenant recovered the possession of his holding under any law in force, for the might have been outed. That is not relevant, my lord. So, my lord. So, I am my lord, the occupancy tenant. My uncle was an occupancy tenant who adopted me, my lord. And after his demise, he continues to be the occupancy tenant till his demise. And after his demise, my lord, I continues to cultivate the land under the, my lord, the Girish Namashudra and my lord, in interest, my lord. That is the factor. My lord. Now, in view of that settled position of law lordship, I'll take my lord to the, my lord, the, my lord, the position of the PWD 2, PW3, my lord. PW3.
Have you enclosed it with your appeal?
My lord?
You enclose it with your appeal?
No, no, my.
It is available at the
LCL.
LCR. Okay.
It is LCL. It's PW3, my lord. And the PW3 is the son of my Girish Namashudra. And PWD, my lord, 2 is the daughter of Girish Namashudra. So they are brothers and sisters in relation. Huh?
That's okay. You can be sure. बोलो तो सामने से PW
3 law. PW3, my lord. He is
Yes.
Roshik Roy, my lord. Now, if your lordship might look into the, my lord, the cross-examination, my lord. I'm just really cut short, my lord. You're taking my lord to the cross-examination. Is in vernacular, my lord.
Vernacular, but it will be difficult to.
Lordship.
It will be difficult to parse.
Or my lord,
Anyway, let us try.
or lordship may, huh? My lord may to translate, make them a translation of that, or my lord.
If I fix another date in the meantime, then it's translate and
Translate and my lord of the evidences.
So you don't have the translated copy.
don't have the translate copy on the vernacular.
Only on vernacular, my lord. It is from the Kacha. In Bengali, my lord. I can read, but I do not like to cause inconvenience to my lord.
আপনার হচ্ছে ইয়ে করতে হবে ট্রান্সলেট করতে হবে
Around.
So how many witnesses are there?
My lord, they actually plaintiff, there are 4 witnesses on part of the plaintiff, my lord.
Defendant 3.
And defendant 3.
And how many defendant
3, my
witnesses?
lord, 3.
3.
Defendant witness 3 and the plaintiff witness, my lord, 4. Acha paper book. Previously, it was there, my lord. They used to prepare the paper book, lordship is forever. Nowadays, that has been done away. So it is really good problem. We have to pay the cost, but nevertheless, that was not something.
Okay.
So for earlier.
We'll direct the estate to translate this into
Yes,
English.
yes. Lordship, that is convenient.
Okay. Heard, Mr.
Vijay Ghosh. Vijay Ghosh.
Learned Counsel for the appellant and Mr. Soduri, Learned Counsel for the respondent. Heard in part, recessal is the matter as parted
After vacation, Lordship.
after vacation.
On 30th October. Sorry.
In the meantime, it is provided that recessal translate PW, all the PWs and DWs from vernacular to English, and furnish a copy of the same well in advance to learned advocates of both the parties.
Obligation.
Paper বনাইছিল আজিকালি নবনাই।
Coming item number 3.
May it please your lordship. My lord, the appellant here is the plaintiff and filed a suit for specific performance of contract in 2004, which was decreed in his favor. Thereafter, the defendants went for an appeal, which was reversed, and now the second appeal. My lord, two substantial portion of law is framed, whether the statement of PW 1 and 2 are perverse, and whether the degree of specific performance of contract should have been done. My lord, I take your lordship to the appellate
So
judgment.
whether the second question is properly framed,
My lord,
second substantial question of law.
whether the decree for specific performance of contract was rightly passed.
For approaching the court promptly, for approaching or not approaching the court promptly.
My lord, that cannot be a substantial question of law. That is a question of fact. That cannot be a substantial question of law. To approach the court promptly or not is a question of fact. Or it can be said in that way, my lord, the substantial question of law is made in that way, whether that exhibit to, whether the time is the essence of contract or not. In a specific performance of contract, whether time is the essence of contract or not.
No, whether a word not is required for before the word approaching.
Well, that I think, don't think, well, that is not required. Not is not required. Maybe a typing mistake. Whether you promptly.
You read the second question.
Well, I don't have the second question. Well, whether the court can refuse to pass a decree for specific performance of the contract for approaching the court promptly. Whether the court can refuse to pass a decree for specific performance of contract for approaching the court promptly.
Whether the word not is required before the word approaching.
But in here, there is no not, my lord. In our order, there is no not. Maybe there is a typing mistake.
Pardon?
There may be a typing mistake, but here what we find, there is no not.
No, not is here. In the main question also, in the order sheet also, word not is there, not there.
I don't think not is required. Not for approach. whether the court can refuse to pass a decree for specific performance of contract for approaching the court promptly. Not approaching the court promptly, we cannot be there. Madam. Refuse and not will not go simultaneously. Refuse and not. Refuse and can approaching the
Whether it carries any meaning, that's how.
well, it doesn't carry meaning. That is why refuse and not two are negative. That cannot go.
No, my question is whether this substantial question of law carries any meaning.
Well, it doesn't carry meaning if the not is there.
If no, not is not here. Otherwise also, whether it carries any meaning.
But if the judge, because if there is the exhibit 2, the exhibit 2 stated that after payment of the initial amount within 4 months, the registration of the sale deed should have been done. So, my lord, whether under the specific performance of contract, we have to approach within 3 years. Whether we have approached the court in the right time or not. Section 20.
Section
20, my lord.
specific purpose. At the same time.
Of specific performance of contracts or specific relief.
Section 20.
20.
Yes.
The jurisdiction of to decree specific performance is discretionary, and the court is not bound to grant such relief merely because it is lawful to do so. For the discretion of the court is not arbitrary but sound and reasonable, guided by judicial principle and capable of correction by a court of appeal. The following are the cases in which one may properly exercise decree not to decree. The following are the cases in which the court may properly exercise discretion not to decree specific performance. Where the terms of the contract or the conduct of the parties at time of entering into the contract or other circumstances under which the contract is entered into are such that the contract, though not voidable, gives the plaintiff an unfair advantage over the defendant, or where the performance of the contract would involve some hardship on the defendant, which he did not foresee, whereas in non-performance will involve no hardship on the plaintiff or the defendant entering a contract under circumstances which, though not rendering the contract voidable, makes it equitable to enforce specific performance. But here it should have been, but now contract 20 says that judgment has come over that it should be within 3 years or 4 years.
Yes.
And my lord, here the suit was the exhibit 2 was of the year 2002, and my lord, we have filed the suit in 2004. So it was within specific period. The suit property is 3.5 acres. The agreement was done on 30/7/2002.
From where you were reading?
My lord, your lordship will find in the appellate judgment, in the decree or in the appellate judgment itself, my lord, your lordship will find in page 15. Page 15, third paragraph, for the sake of convenience, I propose to discuss the issue number 4 and 5. which are the vital issues in this case. Issue number 4 relates to whether the defendant is bound to execute the registered sale deed as stipulated in the deed of agreement dated 37/2002. And the suit is dated title suit number 2026 or 2004. So within 3 years we have filed it. My case before your lordship is, my lord, that here, first of all, your lordship will just look into the issues in the appellate court judgment in page 14. Whether the issue number 3 and 4, whether the suit is maintainable in the present form, whether the defendant is bound to execute the registered sale deed as stipulated in the deed of agreement dated 37/2002, transferring the suit land in favor of the plaintiff. My lord, now while discussing 3 and 4, issue number 3 and 4, my lord, the appellate court has discussed the PW1, PW2, and PW3. My lord, your lordship may look into, may I read PW1? PW1, Madhav Nath in his evidence as on affidavit on his point has mentioned as principal defendant Girish Chandra Das, due to his financial need, wanted to sell the suit land in favor of the plaintiff by paying consideration amount of rupees 1,90,000, and in respect of the deed of agreement was executed on 37, it should be 2002. And the plaintiff has paid rupees 50,000 to the defendants as advance money, and there was a clause in the said agreement that within 4 months they will pay the balance amount and the defendant would execute the registered sale deed in favor of them. PW1 Madhav Nath further stated in his evidence on affidavit that before execution of the sale deed, defendant will obtain necessary permission from Revenue Authority, but in spite of several reminders, defendant delayed the execution of the sale deed, and on 27/11/2002, they had informed the defendant that they will remain present in Borpeta and the balance consideration amount for execution of the sale deed, but defendant did not turn up. He further stated that in his evidence on affidavit, he searched several places, and on 6/12/2002, they met defendant and requested him to execute the said sale deed on that day, but defendant flatly denied, and finding no other alternative, they instituted this suit with a prayer directing the defendants to execute the sale deed through court and also to realize compensation. Said witness also, through his evidence, proved the exhibit document. Exhibit 1 is the Jamamandi, and Exhibit 2 is the said agreement executed by Girish Chandra Das, principal defendant, in favor of the plaintiff. This is my statement before the court. But I take your lordship directly to now page 18. Statement of DW1. Evidence of the defendants, that is their appellants. DW1 Girish Chandra Das in his evidence on affidavit stated the plaintiff volunteered to take permission of transfer of suit land from revenue authorities, and accordingly they obtained his signature in the said permission. But they obtained his signature in the said permission. But after that, they kept quiet and never approached him nor offered to purchase the suit land as per conditions set forth in the Bainama, which is stipulated period of 4 months from the date of execution of the agreement of sale dated 37/2002. And accordingly, the plaintiff themselves violated the condition of the agreement for sale. He further stated in the evidence on affidavit, he approached plaintiff for several times, but lastly on 26/11/2002 and expressed his readiness to execute the sale deed, but the plaintiff evaded performance on their part of contract. He further stated in evidence on affidavit that plaintiff failed to perform their part of contract within the stipulated period of 4 months, so the plaintiff is not entitled to get any relief in this suit. In his cross-examination, the learned counsel on behalf of the plaintiff, he has categorically stated that he put his signature on the petition seeking permission for sale, but could not able to say on which date same was granted, nor he had inquired the plaintiff whether the permission was granted or not. He himself has said it, my lord, that I failed to get information whether the plaintiff has got the permission or not, and which date it was signed, he has not said, my lord. He has failed to that. He denied the suggestion put forward by the learned counsel on behalf of the plaintiff that after obtaining permission, plaintiff side approached several times to him, but he did not execute the sale deed. This is the first perversity in the judgment in discussing the DW1's clause. That he has said that he put his signature seeking the permissions for sale, but could not able to say on which date the same was granted, nor he inquired the plaintiff whether permission was granted or not. He himself was silent that about the inquiry whether the permission was given by the authorities or not. Now, my lord, the court has held in page 21. Findings. Here in this case, third paragraph. Here in this case, plaintiff responded in their evidence has mentioned that within the stipulated period of agreement, they had approached the defendant to execute the sale date, but defendant failed to execute the sale date, and lastly on 6/12/2002, defendant appellant flatly denied to execute the sale date. Peruse the exhibit 2 document minutely. The said document was executed on 30/7/2002. Within 4 months, plaintiff respondent is to pay the balance money, and defendant appellant will execute the sale deed in favor of the respondent. As defendant appellant has failed to execute the sale deed, he came to the court and filed the suit on 18/6/2004, 1.5 years after refused by the defendant appellant to execute the sale deed. So the plaintiff respondent did not take prompt steps for specific performance of contract. But within 3 years, I can file it. There is 1.5 years. He himself has said the court. Moreover, other witness of PW3 in his cross-examination has categorically stated he never met defendant number 1 after execution of the agreement of sale. So he could not say anything whether the plaintiff was ready and willing to perform the part of the contract. A said witness did not say anything that plaintiff respondent was ready with the money in the sub-registrar office, but the appellant did not turn up, and PW2 Paritosh Mondal also did not state anything in his evidence. The plaintiff went to the sub-registry office along with the money on 27/11/2002. And on this finding, the court said that he has set aside the order of the Learned Trial Court in title suit number 26/2004. My lord, now I will take your lordship to the judgment of the trial court. The lordship will. Okay, it starts at page 6. And my lord, while discussing the issue number 4 and 5, page 9, your lordship will find. Page 10, sorry, page 10. Issue number 4. Whether the defendant is bound to execute the registered sale deed stipulated in the deed of agreement dated 37/2002, transferring the suit land in favor of the plaintiff. The defendant agreed the acceptance of 50,000 as earnest money to sell the suit land, describing Schedule B of the claim. The defendant number DW1 stated in his cross-examination that he will not execute the registered sale deed if the plaintiff paid the remaining amount to him. According to the defendant, he will not execute the registered sale deed because stipulated period has already been over. The defendant has also admitted about the execution of exhibit 2, the buy number. It is also found from the evidence of the plaintiff that they were ever ready to pay the balance amount of defendant number 1, and the defendant number 1 after another pretext, avoided to execute the registered sale deed in favor of the plaintiff. Moreover, the terms of the condition of exhibit 2 is binding upon the party, but the defendant number 1 has not abided with the terms of condition of exhibit 2. After careful reading of the evidence on record and other materials available thereon, I found that the defendant is bound to execute the registered sale deed in favor of the plaintiff by transferring the suit land to them by accepting the remaining amount accordingly the issues answered in favor of the plaintiff. Now, if you lordship kindly look into the exhibit 2. It's there by the record, my lord. May I read, my lord? Exhibit 2. It's there in the record. The second.
Yes.
My lord, second paragraph, after 50,000, I will write to start, my lord. হাতাহাতি 50,000 টাকা বাইনা গ্রহণ করিলো বাদ বাকি টকা আজিৰ তাৰিখত পৰা চাৰি মাহৰ ভিতৰত বৰাবত আদায় দি বিক্ৰী দলিল ৰেজিষ্ট্ৰি কৰি নললে বাইনাৰ টকা হাৱা হৈ যাব. So the intention of the parties has to be looked into not only by taking only the 4 months. The intention of the parties is this, that the period will go over after if the registration is not done within the 4 months. And my lord, both the parties have said that the nowhere in this exhibit, this agreement, it has been stated that whether the plaintiff will take the initiative to get the registration done or the defendant will take the initiative to get the execution done. But the plaintiff has specifically stated in his evidence that defendants have said that they will do the registration and thereafter will go for the sale of the particular land. My lord, now on this text, this is the whole case and the facts. Facts and circumstances, this is the whole case. The plaintiff has paid 50,000, 1,90,000 was there. 2002, the agreement was there. 2004, within 1.5 years after denial, my lord, we have filed a suit. We have given evidence. PW2 1 and 2 has said that they have to take initiative and they have refused to go for the particular sale. And my lord, in the DW1, I admitted to the fact that he has signed it, but he has not taken initiative to went and asked whether it has been done or not. He himself in his cross has admitted to that fact. Just now, my lord, again, I will take your lordship to the statement of cross of DW in page 18. Page 18, second paragraph. In the cross, learned counsel on behalf of plaintiff, he has categorically stated that he put his signature in the petition seeking permission for sale, but he could not able to say on which date same was granted, nor he has inquired with the plaintiff whether permission was granted or not. So he never took the initiative to know whether it has been taken or not. So, my lord, my contention is this court has held under section 55 of the Contract Act, and on the basis that time is the essence of the contract, and my lord, 55 of the Contract Act. When a party to a contract promises to do a certain thing at or before a specific time, or certain things or before specific time, and fails to do so any such thing or before the specific time, the contract so or so much of it as has not been performed becomes voidable at the option of the promisee. If the intention of the parties was that should be of the essence of the contract. It is the intention of the parties which should be taken into consideration for the essence of the contract, not only the time. My lord, on that basis, I will rely on a judgment of a Supreme Court, my lord. That is 2006-11 is my lord.
Paragraph number?
Paragraph, my lord, this will be, I think, 84. Starts with 83. Paragraph 84. 88, you'll also be looking to paragraph 88 also.
Yes.
That the question whether or not time was the essence of the contract would essentially be a question of the intention of the party to be gathered from the terms of the contract. Even where the parties have expressly provided that time is of the essence of the contract, which is with such a stipulation will have to be read along with other provision of the contract. And such other provisions may, on construction of the contract, exclude the inference of that completion of the work by a particular date was intended to be fundamental. This is my case. That it should be taken into contract, that the registration has to be done. They have not taken the whole meaning of exhibit 2 is this, that the registration of the sale deed will have to be done within 4 months, and the initiative has been taken by the defendant, and after that fulfillment only, that I will make the full payment and the contract will be done. But they voluntarily refused on a particular date and said that we will not do the agreement. And my lord, another one judgment that I will rely upon, my lord, 2004 8 SCC 689. But prior to that, 2000. Volume,
Mr. Sobri,
my lord.
this paragraph number 88 is the quotation from other judgment.
Other judgment, my lord, that is there.
Where is that judgment?
My lord. Fixed up, my lord, it is, my lord, 1979 to SCC page 70. Bottom it is given, number 2. 1979 to SCC page 70. Your lordship may start from whether the time was the essence of contract from paragraph 85 or not. Your lordship, I'm sorry that I'm troubling your lordship, my lord. From 85 it starts. The question which further arises for consideration is whether the respondent had proceeded on the basis that time was the essence of contract. It was bound to issue a notice of repudiation of the contract subject to reservation as regards its claim of damages. However, stated it had never raised the contention that time was the essence of the contract, but claim arises in view of the delay caused in completion of the contract for a period of 34 months and consequent escalation of cost. And this subsequently, it was held that, my lord, the intention of the parties has to be taken into consideration. And another thing, my lord, that I would rely upon heavily, my lord, that is 2000 volume 10 SCC, page 636. Paragraph number 8.
Paragraph number
8, my lord.
Yes.
Here the case was, my lord, they have elaborated on a particular agreement on a clause. The aforesaid quotation clearly indicates that the obligation to get the sale deed executed was within 60 days. Here, my lord, 4 months. After the document referred to therein was tendered to the plaintiff by the defendant, which in the present case has not yet been done. Here the defendant, they said they have not done. Hence, the trial court fell in error in calculating the period of 60 days from the date of agreement itself to hold laches. In our considered opinion, the obligation to execute the document arises only after the document was tendered by the plaintiff to the defendant, to the plaintiff by the defendant. Hence, the finding of the trial court on this count cannot be sustained, and the High Court is right in setting aside this finding of the trial court. Here in the appellate court, trial court rightly held in our favor. And the appellate court failed to appreciate that and said that it is for the date of agreement 4 months, so it has not been done, you are gone. That is my lord. But here, the defendant had to produce, and they themselves in their evidence have said that they could not had made inquiry, had done anything as regards permission of the sale deed. আদায়দি বিক্রি দলিল
So,
রেজিস্ট্রি
this exhibit two,
exhibit
it casts the duty upon the defendants.
dependent. But here, no specific anything is written. But in our evidence, we have stated, and they have admitted to that fact in their clause. There is nothing specific written here in the exhibit agreement. Who will take the initiative to do the permission, get the permission? But in our evidence, we have everywhere stated that the defendant will take the initiative because he is the seller. He had to sign it. He had to
No,
go
no,
for everything.
unless it is mentioned in the exhibit two, how can you depose to that effect?
Because Malad, here they have said, বিক্রি দলিল রেজিস্ট্রেশন করি নললে বাইনার হল হাওয়া হয়ে যাবে। So the registration is there. The registration, what is there? The registration has to be done. And the registration without permission cannot be said. And they have admitted to that in their evidence. But the defendant number one, in their evidence, they have admitted. Because in everywhere in my evidence, I have stated I was ready and willing to perform my part of contract. And if they don't come, because the seller has to sign the permission and every documents for registration of the sale deed. If the seller does not come, then I cannot go and do it everything. It is, I have always stated in my evidence that I am ready to perform and willing to perform under section 6 of the specific relief act. Under section 16(6), I am ready and willing to perform my contract. I have always stated in this evidence, in my evidence. That is the perversity what the appellate court has not taken into consideration. Everywhere in my evidence, in PW1, PW2, PW3, I have stated that I am ready to perform my contract. I have paid 50,000 in advance. Balance is 1,40,000 I have to pay. But they are not willing because after the escalation of the price, they are not willing to come. They are not executing the permission documents for registration of the sale deed. The trial court held that no, it is the ready and willingness was there on the part of the plaintiff. It is the defendant who have failed to perform the contract. That is why, but here the appellate court held no, the 4 months is from the date of the agreement. So it is on that basis. Time is the essence of contract. So this judgment has gone. But it's not the time of the essence of the contract. It has the intention of the parties has to be taken into consideration. That is what the Supreme Court has said everywhere in deciding section 55 of the Contract Act. The intention of the parties. The intention of the parties was registration of the deed. Registration of the deed presupposes there should be a permission from the appropriate authority. And that should be done by the seller towards the purchaser. Purchaser cannot go for permission by putting his signature. It is the seller who will do the signature and do everything. And he himself in his evidence has stated, I have put my signature, then I have never made any inquiry about that from the place. So that is his intention and it is his delay on his part. Before saying anything that the plaintiff is not willing to perform his part of the contract, he has to show that the part and performance on my contract, my willingness was not taken. In my evidence, I was always saying that I am willing to do and part my performance part of contract. And that was not discussed by the appellate court. Court only held that 4 months from the agreement, so time is the essence of contract, it is not. But the time of section 55 where it says the intention of the parties has also been taken into consideration. That was not discussed by the appellate court. And my lord, another judgment, my lord, 2004, 8 SSC page 689. Para 11 and 12 and 15. Thank you. I'll read para 11, 12, and 15 now. May I read it, Mal? Para 11. But according to Pollock Mullah, Indian Contract and Specific Relief Act, the intention can be ascertained from the
No,
express.
Mr. Roy, so today, this exhibit 2, it is stated that Hawa Ho is above 50,000 rupees.
That will be forfeited. Hawa hoye jabe mane the language.
Yes, that's all right. So, it appears that a duty is cast upon this of Barabar,
Barabar.
Basanta Das.
Your lordship will find. My lord, for registration, I cannot go myself. I have taken he has given the signature, he has admitted in his evidence. I have taken and went to the registration office, but he never approached the registration office. He himself is admitted.
But it is the plain meaning of the exhibit 2.
Plain meaning. He himself has admitted that he has put his signature. I have taken that document for permission to the registration office, but he never approached the registration office. That is his evidence. Your lordship again will read that particular part of the appellate judgment. Your lordship will find. This is DW1's statement, cross, my lord, page 18.
Yes.
Page 18 cross. In the cross-examination by the learned counsel on behalf of the plaintiff, he has categorically stated that he put his signature in the petition seeking permission for sale, but he could not able to say on which date same was granted, nor he had inquired with the plaintiff whether permission was granted or not. So he never went to the registration office only by putting, if he doesn't present himself before the registration office, registration will not be done. He himself has said. Never he made an inquiry, he put his signature and he kept slept over. And he slept over the matter because I took the initiative to get his signature. I got his signature. I went to the registration office. I asked him to come over, but he never came over their office. He never presented himself before the registration office. Without his presence before the registration office, it cannot be done, madam. I have taken the initiative. It is there. I have taken the initiative. I want to get my contract fulfilled. My willingness was there. It himself says that my willingness was there, but he has not present himself, but he himself has said the date was granted, nor he inquired with the plaintiff which permission was granted or not. He never inquired about the matter thereafter. He kept silent over them. I took the initiative. I want to fulfill the contract. My willingness is always there. And my lord, on this matter, this judgment of 2004, there are 11, 12, and 15. My lord.
Okay, continue.
According to Pollock and
yes, para 11.
According to Pollock and Mullah, Indian Contract and Specific Relief Acts, the intention can be asserted from the express word used in the contract, the nature of the property from which the subject matter of the contract, the nature of contract itself, and the surrounding circumstances. That time is not presumed not to be the essence of contract relating to a immovable property, but it is the essence of contract of reconveyance or renewal of lease. The onus to plead and prove that time was the essence of contract is on the person alleging it. It is the defendant who is alleging it. Thus, giving an opportunity to the other side to adduce irrefutable evidence that time was not the essence, not of essence. That when the plaintiff pleads that time was not the essence, but the defendant does not deny it by evidence, the court is bound to accept the plea of plaintiff. In cases which notice was given making time of essence, it is the duty of the court to examine the real intention of the party, giving such notice by looking at the fact of the circumstance of each case. That a vendor has no right to make time of essence unless he is ready and willing to proceed to completion. And secondly, when the vendor purpose to make time of essence, the purchaser must be guilty of such gross default as to entitle the vendor to resign the contract. This is what my case is, and the paragraph 15. Mr. I.L. Learned Counsel for the appellant placed reliance on the judgment of such and such in support of his above contention that time was the essence of the contract. We do not find merit in this argument. Firstly, as stated above, whether time is the essence of contract would depend on the facts and circumstances of each case. It would depend on the intention of the party. Secondly, the fact of the above judgment show that the matter dealt with such and with an agreement for reconveyance, which as stated above presumes that time is of essence. We have referred to contract Mulla herein above, which state in cases of reconveyance or renewal of lease, time is of essence as a matter of presumption which is rebuttable. Lastly, in the case of P. Mithu, it has been held that the rise in price of land agreed to be conveyed may be relevant factor in denying relief of specific performance when court is considering whether to grant decree for the first time. This is not a relevant factor. However, before the Supreme Court of India in SLP stage, where all courts below have granted decree, it was therefore held the judgment of this court in such and such was inapplicable. In the present case, the appellant in the event have not stepped into the witness box, nor have they laid evidence, nor any of this allegation. In these circumstances, we do not wish to burden the judgment by citing various authorities. But here, he has never stated that time is the essence of contract, and in his evidence, he has, in the alternative, has stated that he never inquired about after the signature was put, he never inquired with the plaintiff whether the permission was given or at all not given. So the intention of the parties that the defendant never willing to perform his part of contract, whereas I have done my part and I am willing to perform my part of contract, has been proved, and the defendant's part that he is putting the question that the time is the essence of contract, he has failed to prove it by stating himself in his evidence in his trial that I myself has not inquired after putting my signature. That itself indicates on the facts and circumstances of the case that he never approached the office of the registrar to get his permission and to get the sale deed registered. That is my case, Mala, because the intention of the parties has to be taken not only from the word time is the essence of contract, but taking 4 months from the date of the agreement. That is my case. Intention of the parties has to be taken into consideration. Continue at 2, Mala.
At 2, we have one DC with outline bench.
Item from Itanagar bench. Item number 1, IS Civil 127 of 2024.
May your lordship.
Yes.
Lordship, this IA application has been filed for releasing of EVM, your lordship. The applicant has filed this application for releasing of EVM of in respect of 22 Soki polling station. Before that, your lordship may come to Annexure 2, your lordship. Page number 14.
Yes.
Yes, your lordship. In the same election petitions in the year 2021, IA application was filed for releasing of EVMs. So in that regard, the IA was allowed, partially allowed, but in respect of 22 Soki polling stations, the EVM was detained, your lordship, till disposal of the election petition. And this election petition is of 2019, your lordship. Already press election has also already been conducted.
The question is whether those EVM will be required for deciding the election petition?
Your lordship.
Yes, Mr. Ladi.
Yes, my lord. Yes, my lord. Basically, our challenge is that in the particular polling station, there was a vote capturing. So it will be very much necessary for this while deciding my election petition, my lord. And the Honorable Court has already passed order that all those EVM machine of this particular polling station shall be detained till the disposal of election petition. And without challenging that order, I don't think, my lord, this present application is maintainable.
Yes, Mr. Soki.
My lord, I am for the opposite party. I have no objection as such, my lord.
Acha, you have no.
My-
Okay.
I am for the return candidate.
So, madam, if the EVM will be required for deciding the election petition, then if you release the same at this stage, it will frustrate the petition.
Lordship. Here, your lordship, in the main election petition, your lordship,
So,
the stage,
why those EVMs are required to be released at this stage?
your lordship, there's directions from Election Commission of India, your lordship. The
Maybe, but,
EVMs
but those EVMs were kept
in the strong
as
room,
per
your lordship.
order of this court.
Lordship. So therefore, I'm praying for modification of this order, your lordship.
Okay. Third, Ms. N. Anju, Learned Counsel for the applicant. And Mr. D. Ladi, Learned Counsel for the respondent number.
In IA application, opposite party number 1.
Opposite party, respondent number 1, and Mr. D. Soki, Learned Counsel for the respondent number 2.
Lordship.
In
Two.
IA,
Yes, your lordship, in IA.
this interlocutory application is preferred. By a district election officer, Upper Subansiri district, for releasing electronic voting machines within bracket EVM stroke VVPATS of 22 Soki polling station for further use, which are kept in a strong room under custody of the district election officer Daporizo, Subansiri district, in respect of 24 Daporizo within bracket ST Assembly constituency. Ms. Onjo, Learned Counsel for the applicant, submits that the aforesaid EVMs are required for further use. Whereas Mr. Ladi, Learned Counsel for the respondent number, opposite party number 1, submits that at this stage, the said EVM cannot be released, as the same will be required for deciding the election petition number 08 within bracket AP of 2019. However, Mr. Soki, Learned Counsel for the respondent number, opposite party number 2, submits that he has no objection in the event of allowing this application. Pero having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the order of this court dated 28/1/2021. Pero having heard the submission of learned advocates of both the parties and taking note of the submission of learned advocates of both the parties as well as the order of this court dated 28/1/2021. This court is of the view that at this stage, the EVMs as prayed for cannot be released. Accordingly, the petition stands dismissed.
Obliged.
Most obliged.
Item 3 to continue.
May please, your lordship. I'm for the defendant, your lordship, in this case.
You are for?
Defendant, your lordship,
Yes.
the respondent. The suit has been filed under the provisions section 16 of the specific relief act, your lordship. And under this provision, your lordship, clause C, it is specifically written that he has performed or has there are personal bar, your lordship, in the specific relief act, and the bars are in clause C. First thing is that one has not only to aver but also has to prove whatever he has stated in the plain, your lordship. And here it who fails to prove that he has performed or has always ready and willing to perform the essential terms of the contract, which are to be
You
performed by
are reading the line.
lordship, the provision, your lordship, from the provision section 16 of the specific relief act, your lordship. The provision is clear that one has not only to aver but also has to prove his contentions, your lordship.
16.
16C.
Your good name?
H. Burag, my lordship.
Yes.
Section 16 clause C, that there are personal bars to relief. Specific performance of a contract cannot be enforced in favor of a person. Number A, who has obtained substituted performance of contract under section 20. Number B, who has become incapable of performing or violates any essential term of the contract that on his part remains to be performed, or act is fraud of the contract, or willfully acts at variance with or in subversion of the relation intended to be established by the contract. In the instant case, your lordship, these two clauses are not relevant. I'm emphasizing on clause C, your lordship. Who fails to prove that he has performed or has always been ready and willing to perform the essential terms of the contract, which are to be performed by him, other than terms of the performance of which has been prevented or waived by the defendant. So one has to prove their contentions, your lordship. If I may, lordship, do your lordship kind attention to the agreement entered between the parties, your lordship. Exhibit 2.
Exhibit 2.
Exhibit 2, your lordship. If I may read it.
Yes.
উপৰোক্ত বৰাবৰ দায় পৰা নগদ হতাহতি 50,000 টকা বাইনা গ্ৰহণ কৰিলো। বাদ বাকি টকা আজিৰ তাৰিখৰ পৰা 4 মাহৰ ভিতৰত within 4 months বৰাবৰৰ আদায় দি বিক্ৰী দলিল কাৰ্যকাৰী কৰি নললে বাইনাৰ টকা হাৱা হৈ যাব। তাত বৰাবৰ দয় বা তেওঁলোকৰ কোনো উত্তৰাধিকাৰী ৱাৰিছে কোনো প্ৰকাৰৰ ওজৰ আপত্তি কৰিব নোৱাৰিব আৰু কৰিলেও আইনত অগ্ৰহ্য হ'ব। উক্ত ম্যাদৰ ভিতৰত বৰাবৰ দায় বাদ বাকি টকা আদায় দিয়া সত্ত্বেও মই যদি বিক্ৰী দলিল ৰেজিষ্ট্ৰি কৰি সম্পাদন কৰি নিদিওঁ, তেনেহলে বৰাবৰ দায় আইন আদালতৰ মাধ্যমেৰে তপচিল বাৰ্ণিত বিক্ৰী দলিল কাৰ্যকাৰী সম্পাদন কৰাব লাগিব। If he fails, your lordship, after the payment of the balance consideration amount, only then the defendant will be liable. So the primary fact here is, your lordship, that the payment, your lordship, the payment is the important part in this agreement, your lordship. The 50% has been paid initially at the time of the executing the agreement, but the balance amount has to be paid to the defendant for carrying out the rest process of the permission or registry, your lordship. And it to be done within 4 months, your lordship.
Now, my lordship, I would like to draw your lordship kind attention to the plaint filed by the appellant hearing, your lordship. Plaint is at page 25, your lordship, of the memo of appeal. Paragraph number 4. Page 26, paragraph number 4. That the defendant Girish Chandra Das was in need of money and therefore he prepared to sell the land with house thereon, where the plaintiffs agreed to purchase it at market price.
From who is
Paragraph number 4, your lordship.
yes.
That the defendant Girish Chandra Das was in need of money and therefore he prepared to sell the land with houses thereon, where the plaintiff agreed to purchase it at market price. After negotiation between the parties, the price of the land was fixed at rupees 1,90,000. An agreement for sale was signed between the parties by executing a bynama on 30/7/2002. The earnest money of rupees 50,000 only was paid to the defendant number 1. It was stipulated between the parties that within 4 months of such agreement, the plaintiffs will pay the remaining considerations, money, and within that period, the defendant number 1 by taking departmental permission of sale deed in favor of the plaintiffs and deliver possession thereof. The plaintiffs were always ready with the remaining consideration money for purchasing the suit land, but the defendant number 1 with one plea or other delayed to execute the sale deed as per terms of the agreement. Finally, the plaintiffs were ready with money on 27/11/2002. Your lordship. Agreement was executed on 30 July 2002 and they were ready with the money on 27/11/2002.
Within 4 months? Within
Within
4
4
months?
months, as per their agreement. Your lordship. Request 27, no? Requesting the defendant to execute the sale deed. Finally, the plaintiffs were ready with money on 27/11/2002, requesting the defendant to execute the sale deed remaining present in Borpeta. But it is a matter of great regret that the defendant number 1 did not remain present at Borpeta and no sale deed was executed as per request of the plaintiffs. The plaintiffs thereafter went to meet defendant number 1 with a request to execute the sale deed, but he could not be traced out prior to 6/12/2002. Their contention was that they could not trace the defendant number 1 for carrying out for giving the money, your lordship, the consideration amount. Now, if I will draw your lordship kind attention to our WS filed by us, your lordship. WS starts from page number 29 of the memo of appeal. Relevant portion, your lordship, is at page 30, paragraph 6.
Paragraph,
Paragraph
page number?
6, page number 30 of the memo of appeal.
Yes.
Paragraph 6, second part, your lordship, in reply to such statements. In reply to such statements, the defendant states that the plaintiff procured from the defendant an application addressed to the revenue authorities for permission of sale, and they themselves volunteered to obtain the permission from the revenue authorities for sale, but they kept quiet and never approached the defendant nor offered to purchase the suit land within the stipulated period of 4 months from the date of execution of the agreement of sale. Your lordship, from this, we can make out, your lordship, that they were silent in the plaint regarding obtaining any signature. It was on the part of the plaintiff to go and seek the permission and do the needful for registering the sale deed, Your Lordship, but they remain silent. We have given the signature, but it was only part of the plaintiff to go before the registry, Your Lordship. Paragraph number 7 of our WS, Your Lordship. Next page, page number 31. If I may read you. Rather, in reply to the statements made in para 4 and 5 of the plaint, the defendant states that the defendant served in Borpeta Road, PHC, and stayed at Borpeta Road from 31/1992 to 10/1/2003. It is an averment made by the plaintiff that they could not trace us in Borpeta, but I was serving in Borpeta as a chief medical and health officer, Your Lordship, from 1992 to 2003. Borpeta Road from 31/1992 to 10/1/2003, being promoted to Chief Medical and Health Officer, Borpeta. The defendant joined the post at the office of the Joint Director, Health Service, Borpeta on 11/1/2003. The defendant was within the reach of the plaintiffs at Borpeta Road within the stipulated period of the agreement of sale, but the plaintiffs failed to perform their part of the agreement within the stipulated period of 4 months from 30/7/2002 to 30/11/2002. So the contention they have made, Your Lordship, that they could not trace us is wrong, Your Lordship. I was there, I was serving as the Chief Medical and Health Officer in Borpeta itself, Your Lordship. Now regarding the evidence part, Your Lordship, I would like to draw Your Lordship kind attention to page 19 of the memo of appeal, Your Lordship, where the evidence has been recorded. Yes. The second paragraph, Your Lord, learned counsel on behalf of Learned counsel on behalf of the appellant in course of his argument has submitted that as plaintiff respondents have violated the terms of the agreement and could not able to prove by clinching evidence that respondents were ready and willing to perform their part of the contract, and the evidence led by the respondent side on this point are contradictory in nature. As per PW1, he along with PW2 and 3 approached defendant and requested him to execute the sale deed in favor of them, but PW2 in his cross-examination did not support the said contention. PW3, Paresh Biswas, also in his cross-examination has categorically stated that after execution of agreement for sale, he never met Dr. Girish Chandra Das. The plaintiff have relied on 2 witnesses, Your Lordship, and at the time of cross-examination, both the witnesses have stated otherwise, Your Lordship, that they have never met the defendant Girish Chandra Das. So this shows that there was no, the plaintiff was never ready and was never willing to execute his part of contract agreement, Your Lordship. Now regarding the one more point has been raised by the plaintiff regarding the limitation period, Your Lordship, that the suit has been filed within 3 years as prescribed by the Limitation Act, Your Lordship. But this Honorable Supreme Court, Your Lordship, in various judgments, Your Lordship, and I'll be citing one judgment, has specifically held that it is not about the limitation period which has been granted by the Act, Your Lordship, but if a specific period of time is mentioned in the agreement, that will have the pivotal role in taking into consideration. And in the instant case, Your Lordship, it was 4 months. So in that circumstances, Your Lordship, when the case has been filed, the agreement was executed on 37/2002.
Where is that judgment? Paragraph number?
Your Lordship, paragraph number 20.
Yes.
Whether time has the essence of the contract, Your Lordship.
Hmm.
Before venturing into the aforementioned issue, we must highlight and throughout the entire dispute, appellants have taken a consistent stand of time-bound performance being an essence of the contract. They have maintained that sale deed was needed to be executed necessarily on the date of execution as agreed between the parties. It is unfortunate that all the courts below have failed to render a finding on this aspect, despite the fact that this was one of the key defenses taken by the appellants in respect of the prayer seeking specific performance. In this respect, we must now take note of section 55 of the contract act, which stipulates the aftermath in case of failure to perform contractual obligation at fixed time. If the provision is there, Your Lordship, effect of failure to perform at fixed time in contract in which time is essential. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times and fails to do so, any such thing at or before the specified time, the contract or so much of it as has been performed becomes voidable at the options of the promisee, if the intention of the parties was that time should be of the essence of the contract. Here, it is specifically written that within 4 months, the payment has to be made, Your Lordship. But they could not prove that they have made any approach for making the payment. And it was also reflected in the exhibit 2, Your Lordship. That the amount paid in where it is written in vernacular that বাদ বাকি টকা আজিৰ তাৰিখৰ পৰা 4 মাহৰ ভিতৰত বাৰাবৰে আদায় দি বিক্ৰী দলিল কাৰ্যকাৰী কৰিব নোৱাৰিলে বাইনাৰ টকা ভাবা হৈ যাব। Then I am relying on other two judgments, Your Lordship. It is with regard to the readiness and willingness, Your Lordship. 1996 4 SCC 526. Paragraph number 2 of the state judgment, Your Lordship. 1996 4 SCC 526. His Holiness Acharya Swami Ganesh Desaiji versus Sitaram Thapat. In paragraph number 2, Your Lordship. There is a distinction between readiness to perform the contract and willingness to perform the contract. By readiness may be meant the capacity of the plaintiff to perform the contract, which includes his financial position to pay the purchase price. For determining his willingness to perform his part of the contract, the conduct has to be properly scrutinized. There is no documentary proof that the plaintiff had ever funds to pay the balance of consideration. Assuming that he had the funds, he has to prove his willingness to perform his part of the contract according to the terms of the agreement. The plaintiff was to supply the draft sale deed to the defendant within 7 days of the execution of the agreement. And in the instant case, he has to make the payment within 4 months, Your Lordship. The draft sale deed was not returned after being duly approved by the petitioner. The factum of readiness and willingness to perform plaintiff's part of the contract is to be adjusted with reference to the conduct of the party and attending circumstances. The court may infer from the facts and circumstances whether the plaintiff was ready and was always ready and willing to perform his part of the contract. The facts of this case would amply demonstrate that the petitioner plaintiff was not ready nor had the capacity to perform his part of the contract, as he had no financial capacity to pay the consideration in cash as contracted and intended to bide for the time which this entitles him, as time is of the essence of contract, Your Lordship. And this case was referred in the recent judgment of the Honorable Supreme Court arising out of SLP Civil number 2246 of 2017, Your Lordship. P. Ravindranath and another versus Sasikala and others. The judgment is dated, Your Lordship, 15 July 2024. Recent judgment, Your Lordship.
Paragraph number?
Paragraph number, Lordship, page 25, Your Lordship. the judgment of His Holiness Acharya Swami was relied on the judgment, Your Lordship. Page 25. C. Your Lordship, may I also come to page 29, Your Lordship. Roman 8. Roman 8, it is clear from the record that the defendant number 1 had given a written notice in September 1981, then legal notice in November 1981, and also another communication in December 1981 requesting for payment of balance sale consideration, and thereafter communicating that advance amount had been forfeited and the agreement to sell had come to an end as the plaintiffs failed to get the sale deed executed within 3 months. After December 1981, the plaintiffs kept silent. They neither responded to the last communication of the defendant number 1 of December 1981, nor did they take any steps to file the suit for specific performance of contract for more than 1.5 years. Same in the instant case also, legit. Half years after the defendant number 1 had communicated forfeiture of the earnest money and the cancellation of the agreement to sell. There is no communication from the plaintiffs after December 1981. Here also, Your Lordship, there was no communication since 2002, till the time the suit has been filed. There is not even a notice by the plaintiff before filing the suit of showing their readiness and willingness by tendering the amount of balance sale consideration and sending a draft sale deed for approval. In the instant case also, no notice was sent to the defendant, Your Lordship. They kept silent. Rather, the evidence shows that, Your Lordship, they have never approached. The witness they has relied upon, Your Lordship, in their cross has submitted otherwise, Your Lordship. In my humble submission, Your Lordship, the appellate judgment is not required to be interfered with. Your Lordship. Okay.
Your Lordship,
Okay.
promise me for a simple reply to that. I will just rely upon that in a section 55 case, for a time there is a time is the essence of contract. It is always to be presumed in case of individual property, time is not the essence. That's when if it is specifically written, then one of the intention of the parties has to be taken into consideration. My lord, I will give the judgment, my lord, 67 page 868, paragraph 4, 5 and 6. Supreme Court, 67 Supreme Court, 868, paragraph 4, 5 and 6. The facts which have a material bearing on the first question have already been set up. Section 55 of the contract deals with the consequence of failure to perform an executory contract at or before the stipulated time provides by the first paragraph. Then, my lord, they have quoted 55. Then, my lord, it is not merely because the specification of time at or before which the time to be done, thing to be done under the contract is promised to be done and default in compliance therewith, that the other party may avoid the contract. Such an option arises only if it is intended by the parties that time is the essence of contract. Intention to make time of essence, if expressed in writing, must be in language which is unmistakable. It may also be inferred from the nature of the property agreed to be sold, conduct of the parties, surrounding circumstances, at or before the contract. Specific performance of a contract will ordinarily be granted notwithstanding default in carrying out the contract within the stipulated period, if having regard to the express stipulation of the parties, nature of the property and the surrounding circumstances, it is not equitable to grant the relief. If contract relates to sale of immovable property, it would normally be presumed that time was not the essence of the contract. Mere incorporation in the written agreement of a clause imposing penalty in case of default does not by itself evidence an intention to make the time of the essence. Then they have discussed about it. This is my submission. It is always to be presumed that time is not the essence of contract. It is specifically written, then the intention of the parties has to be taken into account. And around the facts and circumstances and other situation of that.
Okay. Okay, you celebrate that. That's it. Art Mr. P.K. Roy Sodari, learned counsel for the FLM, and Mr. Buragohai, learned counsel for the respondent. Argument concluded, judgment reserved.
Okay.
Coming item 9 and 10. Coming item 9 and 10.
Lordship, the honored counsel for the appellant is not present. Counsel for the appellant is not present, Lordship. But a few minutes back, I have seen him here. He was here, Lordship. He left. Lordship may take it up after some time. Okay, after some time then.
Coming item 14.
This is the field when against the order of remand. My lord, remand, Supreme Court as well as High Court say the remand should not be ordinarily done. If possible, it should be disposed of because it. Well, I shall try to now. Your losses will see the interim order. My lord. At page my lord 49, 48 and 49 stars. This appeal is directed against a judgment so and so passed by Silchar. Sort of still facts leading to file this appeal may shortly be stated that the original plaintiff, namely Ramesh Chandra Paul, predecessor of the present.
Whether there was a report of this fingerprint expert.
Well, fingerprint expert had given a report. Then some questionnaires were given. Everything has been done. In spite of that, my lord, the person in whose my lord they say he denied it. Thereafter, also again, my lord, it has been sent back. I do not understand, my lord. I have got this. This could have been disposed of by the appellate court himself, my lord. You'll also see the my lord.
So the expert was cross-examined.
Expert, my lord, expert was not called for, but some questionnaire was given. If you'll also see, my lord, the
paragraph 23 of page 61. The evidence of fingerprint impression is admissible. But the person giving opinion in the other case must be an expert. Comparison is to be made to the finger impression for beyond doubt or admitted. Expert opinion of fingerprints has the same value as the opinion of another expert, such as medical opinion. In such case, evidence is only guide to judge its value. The evidence of an expert is in the nature of an opinion expert. It is advisory in nature. It is not conclusive. It is not substantial evidence. However, the courts, if you are acting on such experts' evidence, insist on corroborative evidence. It is not a rule of law, a rule of caution and prudence. The way of the evidence is dependent on the correctness of the report and the reasons given and the expert in the field.
So you are reading which part?
Well, paragraph 23, page 61.
So this is the judgment of appellate court.
Yes.
Para 21. Yes.
Paragraph 23, my lord.
23. Okay.
Evidence of the fingerprint impression is admissible, but the person giving opinion in other case must be an expert. Comparison is to be made the fingerprint expression for beyond doubt. Admitted expert opinion on the fingerprints has the same value as the opinion of the any other expert, such as medical opinion. In each case, the evidence is only to guide the judge of this. The evidence of an expert is in the nature of opinion evidence. It is advisory in nature. It is not conclusive. It is not substantive evidence. However, the court, before acting on such evidence, insists corroborative evidence. It is not a rule of law. The rule of caution and prudence. The way of the evidence is dependent on the correctness of the report and reasons given and the expertise in the field. Here in the extending upon perusal of the entire case record, it appears that defendant objected a report of the commissioner seeking time for filing formal objection before the learned trial court. But interestingly, learned trial court, by an order that so and so, held that there is no necessity to file an objection or expert opinion, as the matter shall be raised at the time of hearing. Moreover, the learned court below has reflected in the judgment that defendant side examined the expert on commission by sending interrogatories, and his answer was received accordingly. Well, this is a very important matter. But the existing record does not give an indication that any of such interrogatories were either sent or received by the court. Moreover, the reply of any interrogatories are not from the mouth of its maker, that too on oath. So, admission of such opinion on the basis of interrogatory, even if there cannot be acted upon under facts and circumstances of the present case. So, considering the matter, I am of considered view that examination of fingerprint expert is such pronoun by having a justification. Non-examination of fingerprint expert in the present factual case is not fair. It found to be fatal and prejudicial. But I do not understand what this is. But here you also see that if the person who denied it, so that is the your loss will find, my lord, the plaintiff himself says at page 50, last two sentences, my lord. Accordingly, plaintiff became apprehensive, began to search the sub-registry office to verify the fact of denial of the plaintiff in respect of schedule. The plaintiff found to utter surprise that salary number so and so has been forged in favor of the defendant. Number one, purport to be executed and registered in respect of the Schedule 1 properties. The plaintiff never executed any salary at any point of time. The plaintiff himself says, my lord, I have never executed it. And moreover, the expert opinion is there. So this is a corroborative evidence, my lord. This is sufficient, my lord. That is what I am. All the Supreme Court judgments say that corroborative, my lord. That is, my lord, from 73 onwards. Same. . . . the I'm giving another list, last 70 is also there. My lord. Paragraph 6 in 73, my lord. Thank you. 686. In our view, the legal position answering of so-and-so case Sukha cannot be said to inconsider the ratio of any one of the earlier decisions which appears to has been made therein. Now it is no doubt true that opinion of an expert given in the case no less than valuable than any other expert opinion used in evidence, which with the result that such evidence has to be received with care. But this opinion evidence is which is relevant, may be worthy of acceptance if there is internal or external evidence relating to a document in question supporting the view expressed by the expert. Here, my lord, the plaintiff himself says that it is not my view. It's false. The same view as expressed in the 2012 SEC also, my lord, same. Paragraph 24 to
Not
28.
necessary, but law is well settled.
My lord?
Law is well settled.
Law is well settled, my lord. And moreover, remand also, law is well settled, my lord, that should not be when the evidence is sufficiently the appellate court should decide it. Even Supreme Court has in one case, my lord, did not send back the record to High Court and decided it himself, my lord. I just 99.
Yes.
The issue framed by the trial court, page 38, issue number 9.
Page number 38.
Whether the registered deed number 5615 dated 12/8/77 of the Office of the Joint Secretary is a false law. That to be replied, false or not. So, my lord, the matter was sent to the forensic report. Now I am coming to the appellate court judgment. Page 50. And the my lord, coming to page 38, my lord, I am coming how the answer replied by the trial court. Issue number 6 and 9 are two sides of the same coin. Therefore, I take up together the plaintiff side alleged that the original plaintiff never sold any land of the original defendant number 1 Exhibit 3 in favor of the latter exhibit court document. At the instance of the plaintiff side, two thumb impression registers are being deputed the plaintiff and other admitted signature of the original defendant number 1 called for, or from the concerned officer, and the same were sent to the expert along with the specimen signature handwriting of the original plaintiff, original defendant number 1. Expert ultimately opined by the exhibit number 1 that the persons who wrote blue control so-and-so did not write up the disputed question signature. Thumb impression registered dated so-and-so, and the persons who wrote blue and two signature serial S150 S4 specimen Bengali handwriting original defendant number were writing the words Ramesh Chandra Pal, which happens to be the name of the original plaintiff. B1, B3 specimen signature of the original defendant number 1 Bengali, and the one admitted signature of the original defendant number 1 in Bengali on the concerned thumb impression registered page number 90. Also wrote the disputed question signature purport to the original plaintiff in thumb impression. So, in other words, it was the original defendant number 1 and not the original plaintiff who appeared before the registering authority at the time of registering disputed documents said deed number. This clearly goes against the claim of the defendant side that it was the original plaintiff who got the deed registered in absence of the original defendant number 1. This in turn also raises a presumption that it was not the original plaintiff who executed the disputed sale deed, and the deed has all along been custody of the defendant side. In support of this, my lord, there is no analysis of it in the trial court judgment. These are the judgments of the trial court, the Supreme. It may be noted here that disputed document in original
could not be sent to the expert because either side claimed that it is in the custody of the opposite side. So photocopy was sent, not the original. However, it can be gathered from the expert report that it is the original defendant number 1 who appeared before the registering authority for its registration, and hence document is likely to remain in the custody of the defendant side. These are my presumption. Otherwise, when the defendant claims that the original defendant number 1 purchased rights over the land by virtue of that document, they are presumed to be proper custodian of the document, presumed. That the original plaintiff did not return the document does not revert the presumption, particularly with the expert's opinion. That the plaintiff did not appear before the registering authority at all. Both the DWs did cross-examining them, they were present at the time of the execution by the censor. Then I'm skipping their portions. I'm coming to page 39, para 11, how that has been declared. It is true that the opinion evidence of an expert is not conclusive and that the plaintiff side has not adduced any other evidence to disprove the document exhibit 3, but it will unjust, in my considered opinion, to expect that the plaintiff side would be able to prove, except expert evidence, that the original plaintiff did not execute exhibit 3 because there can hardly be any evidence of negativity of a fact. By proving the report of the expert, the plaintiff side has at least shifted the onus to the defendants in my considered opinion to prove that the document was really executed by the original plaintiff. Otherwise, even if there were no allegation of forgery, the burden of proving the document exhibit D would lie to the Defendant or Evidence Act as already noted. But defendants have not adduced any evidence in this regard. DWP rather clearly stated that they did not witness the execution of the registration of the document. They have not even produced the original document or given notice under Section 68. Exhibit B is clearly inadmissible. Exhibit B has purported more than 30 claims. Then, my lord, this issue was decided. Now, my lord, I am coming to page 58, the appellate court findings. I have carefully, page 58, para 16. I have carefully reappreciated the entire evidence on record, both oral and documentary. Since the very crux of the matter relates to the issue, I would like to confine myself to the vital legal aspect. Whether the commissioner's report can be looked into by the court without the same being marked in a case and without the commissioner being examined to prove the report. However, the science on fingerprint is useful in adjudicating the dispute, and what is the weight to be attached to the report of the fingerprint expert. The points for determination is whether the judgments so passed by the learned court below is based on perverse, erroneous, and wrong interpretation of law as well as fact. Let me take up the first point of my decision. The plain case of the plaintiff is that he has never sold any land in favor of the defendant number executing sale deed number so-and-so, exhibit 3. And according to him, the defendant number conclusively manufactured the document by impersonating himself before the registering authority concerned. Upon perusal of the case record of the learned court below, it appears that the learned court by order dated 4/12/99 has directed the plaintiff to take up step for obtaining the signature of the original defendant number 1 because the signature obtained earlier was held to be unfit for the examination since it was found blurred. The advocate for original defendant prayed for an advocate commission to obtain the signature of the said original defendant number 1 as his client defendant number 1 is not fit to come to the court giving his thumb impression. The case was fixed on taking on 31/20 for due to holiday. Record was put up on 17/1/2000. Same was fixed taking up the plaintiff, but interestingly on 18/2/2000, WT message was issued from the Director Fingerprint Bureau, Assam, requesting the trial court to depute one special messenger to collect the exhibit and the opinion as the same is ready, and accordingly, report was collected by the special messenger deputed from the district judge office in the light of the order passed by the court on 3/6/2000. So interesting, there is nothing to show as to how, in what manner did the Fingerprint Bureau Guwahati has prepared the report on the basis of blurred and unfit thumb impression. That is why my cross was written. There is no any explanation available of such discrepancy in the case record. That is my cross report. So order then rule 20, I'm skipping it. Page 61 directly, my I'm coming to. A reading of the aforesaid provision makes it clear that the report of the commissioner once submitted to the court shall form part of the record. It is necessary
not necessary that the said commissioner report is to be marked as an exhibit in the case. Similarly, it is not necessary that the said commissioner is to be examined to prove the contents of the said report. It is up to the choice of the party to examine the commissioner in respect of the matters referred to him mentioned in the report. Examination referred to the aforesaid provision is to be understood in the context of the examination referred to the chapter 10 of the Evidence Act. The examination includes examination of chief, cross, and re-examination. In order to substantiate said objection and to request the court not to act on the commissioner's report, with the permission of the court, they have been given an opportunity to examine the commissioner personally in the open court, touching any of the matters referred to him mentioned in this report, or as it examined, or to his examination. Normally, when objection is filed by the commissioner's report contending that said report is incorrect, to substantiate this said stand, it is necessary to party to examine commissioner personally, cross and examine him on those bases, objection to certificate. On these findings of the appellate court has came to the then evidence finger expression is admissible, but the person giving his opinion as in other cases by an expert, comparison is to be made to finger impression proved beyond doubt or admitted. Expert opinion on fingerprint has been the same value as the opinion of any other expert. Such a medical opinion in each case, the evidence is only guide to judge its value. The evidence of an expert is in the nature of the opinion evidence. It is the advisory in nature. It is not the conclusive, it is the substantive evidence. However, the court before acting on such an expert evidence insist corroborative evidence. It is not a rule of law, it is the rule of caution and prudence. The weight of the evidence is dependent on the correctness of the report, reason given and their expertise in the field. Para 24, here in the instance upon perusal of the entire record, it appears that defendant has objected the report of the commissioner by seeking time for filing of the objection before learned trial court. But interestingly, the learned trial court below an order dated 24/2001 held that there is no necessity to file an objection on the expert opinion as the matter shall be raised at the time of hearing. So objection was raised and it was melted. They are not allowed to process anymore. That is on this context, my lord, the judgment related by the senior counsel. My humble submission is that fact situation is divided. Since we raised objection, so opportunity of cross examination. And it was just my lord plot and findings of the appellate. And opinion was collected by the elaborately tell how the report was collected from Guwahati. My lord, my humble submission appellate remanding back limited question on that point only. Allowed examination process. There is my lord. No,
Appellate court.
my lord. Remanding back to the trial court. The ultimate findings is yes, my lord, we remanded back. My lord. The para 28, page 63. So before going on delving into the other aspects of the matter,
Paragraph
page
number?
63, para 28.
Yes.
So before going to delving into the other aspects of the matter, I feel it is a fit case to remand the case to the learned court below concerned to decide afresh in the light of the order passed by this court as follows. In the result, the appeal stands allowed by setting aside the judgment and decrees of passed by the learned court below. The suit is remanded back to the learned court below to decide afresh by examining the fingerprint expert and by giving opportunity to both the parties to cross-examine him. Admittedly, the suit is pending since 1992, since it has been reviewed number and title suit 125 of 7 before the learned Munshi, and as such, the learned court is directed to make all endeavor to dispose the suit within the shortest possible period. So the remand to allow the proper, our objection was not taken into consideration. Well, and the cross-examination, so we left it.
Okay, we will pass the order.
My lord, even court can compare, my lord. Section 5 and.
Yes, provision is there.
Yes.
Court can compare.
Compare, my lord, it tells this for
Court will say.
Court, my lord, appellate court try to compare. But observation is there, why, my lord, required. Appellate court observation is there, why comparison is not possible.
Okay.
All right.
Thank you.
But.
Not here.
Coming item 9 and 10.
No puedo seguir. No puedo seguir.
In the, against my petition under order 2197, they have filed an objection. I'll take a lot to that objection or the plea they have taken. First, Lord, Lordship will come to page 50. I'll just read the relevant part of the objection, Lord.
Who is which item?
It's RSA 16. Lord.
60, okay. Nice. Page number?
50, my lord. My lord, I'll read the relevant part only. Lordship will come to page 51. I'll not read the entire the objection. The Lordship got it on page 51.
Hmm.
Well, may I read it? Page 51. The above made in paragraph 1 and 2 of the petition are somehow true. The statements made by the petitioners in paragraph 3 and 4 of their petition are twisted and ambiguous, inasmuch as the decretal land in respect of this title execution proceeding was exclusively received in exchange of the exclusive property of Dinamoni Chaudhary, but the petitioners tried to adumbrate that as if that the property was received in exchange of Dinamoni Chaudhary and sons of Chandramani Chaudhary. That apart, to the best of the knowledge of the answering substitute decree holders, neither the Dinamoni Chaudhary nor his son Devesh Chaudhary, not to speak of Jageshwar Chaudhary or Mukteshwar Chaudhary, started to reside over the decretal land since the right from 1950. All the relevant facts in detail has been averred in the decree holders, Deveshwar Chaudhary and his sister Sukumari Roy, that is father and parental aunt of the present answering substitute decree holders, in their respective written statement, as has been submitted by them in their connected title suit number 6 of 2007, as was brought to the present petitioner's plaintiff in the court of civil judge, which is still pending for disposal. Now, my lord, the statement made in paragraph 5 of the petition are not wholly true and complete. However, it is true that Dinamoni Chaudhary, that is the father of the decree holder, my lord, Dinamoni Chaudhary died, leaving behind his one son and 5 daughters, whose names have been arrayed as in paragraph 5, and none of them is presently alive, but the names of all surviving heirs have motivatedly not been furnished by the petitioner in their petition. The statement made in para 6 to 14 of the petition are purposeful, superfluous, irrelevant. The statement regarding addresses of the place of abode of Jageshwar Chaudhary and Mukteshwar Chaudhary, so also Suchitra Bala Roy, Sukumari Roy, and their no relevancy in the so and so. The statement made in paragraph 15 to 20 are ill-motivated and does not have any substantiate right, title, interest, or the co-sharer in the decree. This is now the relevant part. To the best of the knowledge of the objectors, substitute decree holders, their grandfather, Dinamoni Chaudhary, had died in the month of February 1956. This is their stand. Not that Dinamoni Chaudhary died in February 1956. And as such, their father, Deveshwar Chaudhary, being the sole son / male heir, inherited the entire property left behind by his father. However, the female heirs of Dinamoni Chaudhary, with a view to evading the rest of least 4
for future confusion regarding absolute ownership of Devashir Chaudhary in their entire decretal property had executed registered gift deed number so and so dated 29/9/1962 in favor of the Devashir Chaudhary. Now, my lord, their case is that Dinamoni Chaudhary died in February 1956. Therefore, 1956 Act, since before 56 Act came into force, therefore, his only son, Deveshwar Chaudhary, the decree holder, succeeded to the property. But as a matter of abundant caution, they said that the other sisters have gifted. My lord, if they do not become the owner, why they will gift the property? This is what, my lord. Because two stand cannot go together, my lord. They say the Dinamoni died February 56, therefore, as a son, only son, Deveshwar, the decree holder, got the entire property. But then they subsequently said that to avoid future confusion, they give deed can be given by whom? He must be title holder. This is what. Now, my lord, I'll take your lordship to the decree that has been obtained, which is sought to be executed. My lord, that is, my lord, exhibited. My lord, if lordship take up the, my lord, exhibits. Exhibit 14, my lord. Exhibit 14. What was the stand, what was decided by the learned court in the decree which is sought to be executed? Title Appeal number 1 of 1998. The judgment and decree passed, my lord, on 28/6/1999 in Title Appeal number 1 of 1990. I'll read the relevant part, my lord.
So this gift deed was executed by the female
Sisters,
members.
by the sister.
Yes.
My lord, I give you. My lord, I give a familiarity that's I pass it.
Oh yeah. Yes, you have given one cert on the other day.
My lord, did I give it to you the other day? my lord?
Anyway, yes.
My lord, you see, Dinamoni is the father.
Hmm.
And on the left, Deveshwar Chaudhary is the son.
Hmm.
He was the owner 50% of the property and 50% was Dinamoni, father and son. And next is Suchitra Bala is the daughter. Mathura Namosuddha is the daughter. Alonna Roy is the third daughter. Sukumari fourth and Maloti is the fifth daughter. These are the sons and daughters. They under the law of succession become 50% 50% owner, my lord, of the Deveshwar Chaudhary's property. Because 50% there was originally 50%, father and son 50-50. From the 50% we are succeeding. 50% which belong to Deveshwar, my lord, Dinamoni Chaudhary. We are the successor in interest of that 50% of the father's property.
Hmm.
Now, my lord, kindly come to the title appeal exhibit number 14.
Okay, record. Title appeal.
Title appeal number 1 of 1998. No, it is not. That's not.
Title appeal. Whether that title appeal was called for,
Should be well there.
but there is no office note regarding
LCR has come. LCR should include the all the.
One of 2013 is but LCR means LCR means one of 2013 is we have received a record of Miss Appeal number 1 of 2023, title execution 03 of 2007, and Miss Case number 85 of 2011.
But my lord, the exhibited documents should form part of the.
What is the number of that title level?
1 of 1990.
One. Title level 4, 6. These are here.
Miss Appeal 1. It's not title appeal, Miss Appeal matter.
Miss Appeal.
Miss Appeal 1 of.
Miss Appeal 1 is available.
That is the first appellate course.
But the title appeal number 1, no. I am not on Miss Appeal, Lord. The decree which they sought to execute, 1998. Which is exhibited at Exhibit 14 in title suit number 3 of this decree.
This decree will be available in the records of Miss Case number 85 of 2011, which was registered on the basis of their application.
No, your lordship will get it on in title execution case number 3 of it is written there.
Yes, 85 of 11 was.
Yes, that is available.
The Miss Case 85 of 11 was registered in the title execution case of 3 of 2007.
Well, should we check up and make it ready for your lordship? Better we go through the documents, will not we make it ready from there to the ready.
Yes, so then let us adjourn it for today.
Lordship, I'll just ask my London friend to make it ready for lordship from the records.
But there is no office note regarding receiving of that record.
I'll also check that.
Yes, kindly check it.
The title appeal record will not be a part of the present proceeding. So that record
No,
It's not.
I'm not on that. Title appeal judgment is an exhibited document. So therefore, that will be there. So I'll check up, my lord, and I'll come back to you, lord.
Madam, that is, we can just find out, madam.
We will do that. We'll both do it, madam.
So we'll fix a sort that.
Lordship.
Otherwise, we can finish it, madam. Let me place my case, madam. I can show that document is, my learned friend will find out.
Today?
Decree, yes. Decree will be available in the report.
No, he has been referring to this title appeal.
Title appeal report will not be available here. madam.
Because that my
Because
whole basis of my case of that.
My lord, title appeal, if it has been exhibited in the present proceeding, then it will be a part of the record, so it will be available.
Okay, second.
Yes.
We'll check it, my lord. Anytime Thursday or maybe next Tuesday.
Next week.
Next Tuesday.
Okay.
Well, that exhibit we'll find out when otherwise it was adjourned once today also it was. We can
No, my
finish
lord,
it.
I have no objection, but when I will have to make my submission on the basis
No,
of
no,
those.
exhibit we will find out. My learned junior will find out the
Because,
exhibit they want. The decree, my learned friend wants, decree we will find out for your lordship, madam. Only decrees, looking for decree is available.
No, I'll rely on other documents as well. I'll rely on the documents and make my.
Okay, second. Let us fix it on next Tuesday then.
Lost next week.
As agreed by learned advocates of both sides, the SSL is the matter on next Tuesday, 17th. 17th September. It will get it.
17th, madam.
17th. Item number 20.
And Mr. Roy, if it is not available.
Madam, my learned friend has got it already. It's already there.
Record.
Yes, madam, that exhibit, decree.
No, he has also relied upon some other documents as submitted by him.
Check up then and then. It's better, my lord.
Okay.
Item number 20.
I have highly miscast lordship. That have not take lordship. Lordship can be allowed 2 weeks time.
1 week time.
1 week time, lordship maybe they fix lordship. As per lordship convenience.
You are for the appellant?
Appellant. After 21 lordship.
After?
After 21.
That's prayed for by Mr. Your good name?
D. Mahanta.
Learned counsel for the appellant. Recess shall list the matter after
2 weeks.
2 weeks.
Obliged.
21.
Well, okay. I have challenged, I have challenged the judgment passed by the additional district judge in a forward case. In a forward, I applied for the letter of administration. That was not allowed, my lord. Here the fact of the case is like this. On Pulawala. On Pulawala Das, who executed a will in favor of the petitioner, my lord, in respect of a plot of land. And that will was executed on 1/7/2012. And the will was executed on 1/7/2012.
Is it part of this record?
Yes.
Page number?
My lord.
It is not part of the record.
Not part of the,
LCRs were called for. LCR, yeah,
okay, copy, this LCA.
LCR. My lord. So after 4 days, she died after execution of the will. My lord, the petitioner who are, the petitioner number 1 is the. is the
So
daughter-in-law.
this exhibit 1 is the will.
Yes, exhibit 1 is the will.
Yes.
So we'll see the will. Will was executed by Phulowala, late Phulowala Das in favor of her daughter-in-law and grandson, a granddaughter, 2 daughters. And respondent are also daughter-in-law and granddaughter. Respondent are also. Phulowala Das had 3 sons, and 1 son died long back, unmarried, and 2 sons. Here the petitioner and respondent are daughter-in-law and granddaughter of Phulowala Das. That's the thing. You also will see that my applications for provide that I have submitted. The Lord will see that application. My application is page number 19. The Lord will see. Page number 19 of my memo of appeal.
Page number 19.
19 is my application. And page number 25 is the written statement. The Lord will.
Why this letter of administration was not granted?
My lord, she died after 4 days. After 4 days, from the date of execution of the will. And that is only the suspicious circumstances. And the court held that she was counting the days for death. She was counting the days for death. And in such a position, she was not have executed the will. That was the finding. But the finding was not based on any evidence, but on presumption. And this is my application here. I've sought the letter of administration because she was not appointed as executor in the will. The petitioner was not executor. So applied for the letter of administration. And the 25, page number 25 is the objection. Mainly, your lordship will see the objection. The main objection is that she was suffering from serious illness, and she
was suffering from
serious illness.
Serious illness.
It is a fact that she was admitted, but it is not that so serious. She could not have executed a will. It is not so. There is no evidence at all to show that she was unable to execute the will. Totally unable to execute the will. There is no such evidence. Anyhow, court has held, and here we examine the five witnesses. The petitioner side examined the 5 witnesses, and the petitioner himself. And 3 and 4 are the attesting witness. 3 and 4, your lordship will see the 3 and 4. Here the cross part, English version of the cross part is submitted. That's the order of the lordship will see. Translated copy.
translated copy of the cost of PW and DW.
You have enclosed with the petition?
No, separately filed in terms of court order,
Separately filed.
separately filed.
Is it available in the
Yes, there is.
appeal?
My lord.
Page number?
The page number, my lord, it is filed.
My lord, there was an order dated 9/5/2024 where my lord, my learned senior colleague was directed to file the translated copies of the cross-examination file.
Hmm.
So that was filed, my lord, by way of additional affidavit.
Filed.
Hmm. Yes.
Oh, no. Oh, see, that's the- Here, whatever the issue here in this case, the basis of the litigant party, the issue was whether the deceased testator Phulowala Das during her lifetime on 1/7/2012 executed one will in favor of the petitioner of the case. Issue number two, whether the will was executed with undue influence of the petitioner by deceased testator on Phulowala Das. Three, whether at the time of execution of the will, deceased Phulowala Das was not in a sound health and mind. Three. Four, whether the petitioner taking the undue advantage of the situation and the circumstances prevailing at the time, fraudulently and obtain the will. Five, to what relief or relief the parties were entitled. The five issues were framed. Only the issue number three was decided. And other issue not at all discussed and not decided. And issue number three was decided.
That is the vital issue.
Yes, three is the no doubt vital issue, but the other issue are also important here. That actually issue number three was wrongly framed. It was
Wrongly?
Wrongly framed, improperly framed, improperly because sound not requirement of the law is not the sound.
No, you were present at the time of framing the issues.
Whether at the time of execution of the will, deceased police officer was not in sound health, and sound health is not requirement. Requirement is the sound mind. Here, of course, here is the mind, but the sound health it is a food that is why it is misdirected to come to the wrong finding. Sound health is not requirement of the law. 59 of the your lawsuit will see the 59. 59 of the Indian Succession Act, not 59C.
Kobe? Section? Mr. Upadhyay, section?
Section 59. Section 59.
Yes.
Person capable of making will. Every person of sound mind, not being a minor, may dispose of his property. The sound mind.
So sound mind is mentioned in the
No.
mentioned in the issue.
I shall place the sound health. Sound health is a different.
No, and sound mind, both are different.
Different sound mind.
Yes, sound health
mind is the
and mind.
Sound mind is the requirement of law, not the sound health. Sound health indicates the perfect health. A person may be suffering illness, he can execute the will. There is no.
No, Mr. Upadhyay, at the time of framing the issues, you were present there and having agreed with the learned trial court. Now you cannot argue before this court that it was wrongly framed.
Imperfect.
No. Cannot be.
That is why the court directed, directed to come to the conclusion that the testator had no sound health. That is not the requirement of the law. That is sound health.
No, where is the finding of the trial court?
Yes. Rather than I have annexed along with my petition.
Page number 13 is that.
Yeah.
Page number
13, 13.
13. That is discussion.
Discussion.
The finding, where is the finding?
Finding is the last.
Page number 26.
Page number 17.
Hmm.
Finding it is 17. Here, I read the finding.
Yes.
26, page number, para 26.
Hmm.
In view of the aforesaid judgment of the Honorable Apex Court, coming back to the fact of the instant case, it is seen that the evidence of the petitioner witness about the execution of the will by the testator appears clouded with the suspicion as under the fluid circumstances, it is well be impossible to execute a will in a sound state of health and mind when every very person who executed a will is counting her days expire after 4 days of the execution of the exhibit 1. Therefore, taking into the consideration all the cumulative facts, this court is of the clear view that their will exhibit 1 was not executed by Phulwala Das in sound state of health and mind, and without influence of the petitioner, because the very way in which the grant of the petitioner deal with the execution proceeding and taken rupees 66 lakhs from the judgment debtor, without knowledge of the opposite, so that they were bent upon to deprive the opposite from getting any share in the property of the Phulwala Das. As such, the court is of the clear view that exhibit 1 is not tenable in law, and that the petitioners are not entitled to get the stamp of the approval of the court to issue the letter of administration in favor of them, as the will was not seems to have been validly executed by the testator on or sound health and mind. This is the finding. And other are the losses will see. Yes, the two judgments, these judgments are not relevant. Here the first, my lord, my humble submission is that the other issues are not decided. With the other issues, without discussing the other issue, your lordship, here the court come to finding that here the 66 lakhs, 6 lakhs was actually, my lord, that is a different part, totally different. It is extraneous consideration, because in respect of the same land, my lord, there was civil suit filed by that my lord, the Puleswari who contested that case, filed by her for eviction, for ejectment of some occupant of her land. And that she won the case, lordship. And the execution proceeding was filed, but not by her, after her death, by her son, by her legal heir. So that proceeding is nothing to do with the will. And here the repeatedly court held that if you are not in sound health, that is not a requirement of the law, my lord. And the other issue are not at all decided, at all discussed and decided. And your lordship, without this, here the other issue, your lordship will say whether the will was executed with undue influence of the petitioner by deceased testator. This is issue number 2, that was not decided. And issue number 4, whether the petitioner taking undue advantage of the situation and the circumstances prevailing at the time, fraudulently and obtain the will. All these issues are the important issues. These issues were not decided at all. Now, your lordship will see my written submission. Both of us have filed the written submission. Your lordship will see. Written
Yes,
Brief written submission, both of us are lordship will see the brief written sub my files.
at page number
Page number मतलब जो file on
before the trial court.
no before this honorable court. And my learned friend also filed.
Mine, I'm fine.
Before this court,
Yes,
before this court,
yes.
when?
My lord, on 6/6/2024, my friend had filed a written argument. I'm yet to file. I have prepared the argument.
কবে এটা
मतलब file
File করা আপনার দিয়েছি।
you have the copy.
না, আপনার দিয়েছি, আমি খালি দিয়ে আনি।
I didn't.
একদম উঠিলে যে,
Oh, okay. So you will also file. Today he will file.
As per direction of this court?
My lord, 6/6/2020.
As for direction, exactly not as for direction.
I was directed to file.
You are directed to file.
Yes.
You are directed.
Oh, a brief written on behalf of appellant. And
There-
you
there
have
was-
also submitted.
My lord, I will submit today, my lord, because the matter was, although it was in the list, but it did not reach on the earlier occasions, my lord.
You were submitting today,
I will submit today. If my lord wants, I will submit today. I will be ready.
but have you served a copy to him?
I have submitted.
Yes, he already.
I have already.
He already served.
It's a-
That is why I was
But the
on
matter
impression
was
that
not-
he already filed, but he said that he has not filed.
Yes,
So, my lord, so far my evidence are PWs are concerned, your lordship will see the cross part. Yes, I do not like to read the in sheet. I like to read the cross part of the PW and DWs because it is very important. PWs, PW1.
Yes.
PW1 Srimati Minu Das. She exhibited a will and signature were duly exhibited. Signature of the test topics were duly exhibited. Here, she said, at present, I am living along with my husband. My husband is a son of Puludas. Puludas had got 3 sons, no daughter. There was a civil case in the civil, and in the civil case, Pulwala Das got decree. Therefore, Pulwala Das died. Later, my husband filed a case for execution of the decree. My husband, in spite of knowing the will, filed the execution case. In an execution case, the opposite party was implemented a decree holder. The execution case is still proceeding. In the meantime, got a new drag and patta mutation of the mutation of opposite party. At the time of the execution of the will, the age of the Pulwala Das was 70. Pulwala Das had got no any ailment at the time of execution of will. The will was executed on 1/7/2012. Pulwala Das was admitted at hospital on 8/6/2012 and on 27/6/2012, the she came to home from the hospital. It is not a fact that Pulwala Das was at home. She defected on the bed and Pulu Das took care of her. A month before the execution of the will, Pulwala Das wanted to make a will. My elder daughter, Dimple Das, called the witnesses. Utpal Das called the Thakur Medi. Java Das is my daughter. She was not present at the time of the executing the will. She was not made party in the case. She should then mention in the will is in possession of the judgment debtor. It is not a fact that Pulwala Das was not in a sound mind at the time of executing the will. It is not a fact that Pulwala Das has not signed the exhibit 1. Thakur Mehdi has shown where to put the signature in the will. In the execution case, my husband has filed a compromise petition and took rupees 6 lakhs. I have filed an application for stay of the execution proceeding. It is not a fact that while executing the will, Pulwala Das was not in a possession of the civil land, hence the exhibit 1 is not admissible in law. And this is the first part of PW1. And Dimple Das is her daughter, PW1 daughter. It is not a fact that Pulwala Das was suffering from ailment at the time of execution of the exhibit 1. Pulwala Das was not required to be taken to hospital. Pulwala Das could not ride before her death. At the time of executing the will, myself, my mother and my uncle, Utpal Das, my friend Sandeep Das, etc. were present. Pulwala Das asked to call the people. Grandmother did not write the will. My mother brought the people by calling them. I do not know the exhibit 1. Grandmother put her signature in therein. It is not a fact that my grandmother was not in a position to execute the will, was unable to put the signature in the will into willness. I fed the medicine to grandmother. It is not a fact that Bulu Das cleared urine and used to if the child by the grandmother on bail. At the time of death, the grandmother was 65 years old. She did not forget the matter. PW3. Utpalji Das on earth. He is a attesting witness. Pulwala Das has called me to be the witness in will, and at that time she was completely healthy. She was able to walk and roam around. The deceased told me about making a will in advance. Pulwala Das had to be taken to the hospital before she died. At the time, she was physically weak. I put my signature at the end of the exhibit 1. I cannot say who first signed the exhibit 1. I cannot say who brought the stamp paper. I do not know about the civil case relating to the land of the will. Pulwala Das was healthy at the time of executing the will. After executing the will, she was taken to hospital. After 4 days of the taking to hospital, Pulwala died. This is signed in the front of me. Thakur Mehdi has shown to Pulwala Das where to put her signature. Daughter-in-law Pulwala Das gave the pen in the hand of Pulwala Das. Another attesting witness, PW4 Sandeep Das. I know Pulwala Das, she is an old lady and she was not sick before. I have not seen Pulwala Das being taken to the hospital previously. Before her death, Pulwala Das was able to walk and roam around. Tutu called me to witness in the will. Will was written by Thakur Mehdi. Will was executed in the name of Dimple. After writing the will, it was not read over to me. Before putting my signature in the will, I do not know whether Pulwala Das had put her signature. PW5 Skype. Exhibit 1 is written by my hand. My signature is at page number 7 of the exhibit 1 and not in the rest pages. In exhibit 1, it is written that the scheduled land is in the possession of the will executor. In the exhibit 1, the signature was taken by me, but I do not know about striking out therein. I took the signature at the striking out. Pulwala Das was not seen lying in the bed when I called at the time of execution of the will. Signature of Pulwala Das were taken by myself in the exhibit 1. I did not purchase the stamp paper. It appears that the stamp paper were purchased on 28/6/1992. I do not know that on that day, Pulwala Das being taken to the hospital. I wrote the will on, it is wrong now. The 92 is wrong here also. Only type. I wrote the will on 2012. It should be 12. It should be 12. So I do not know about the attesting witness of the will. It is not a fact that signature of Pulwala Das were not taken in the will. It is not a fact that I have not taken the signature of the witness. Now, the Bulu Das, the contesting defendant. This is Puluwala was my mother-in-law. TW1, TW1, Bulu Das. This is Bulu was my mother-in-law. I live together with Minu Das at the same house but separately. I have given the address Isha Puruhati. In my evidence, I have not stated how long I have been Isha Puruhati. It is not a fact that in my evidence on affidavit, I have written that I started to live in Isha Puruhati from Karekal after the death of my mother-in-law. I do not know the number of TS execution case. I do not know what is written in Exhibit 1. At present, I cannot say what is written in TS execution case. I cannot read English, but I cannot understand. I cannot understand everything. I cannot say what is written on my evidence on affidavit. I have written the details of my witnesses in my evidence on affidavit. There is no detail of evidence in Exhibit A. I cannot understand the word written in the Exhibit B. Doctor can explain the Exhibit B. In my evidence on affidavit, I have not written that my mother-in-law suffers skin disease. I do not adduce the evidence of doctor to explain the Exhibit B. I cannot say what this is my mother-in-law had as per Exhibit B. I do not know the dark and pata number of the disputed land, but 12 lesa is the land of this case. I cannot say on how much land the decree was passed in PS. On the one side of that land, there is Surya Das. On the other side, there was a Nani Das and Bhavani Das. I do not know the other. At the time of death of my mother-in-law, her age was about 77. I have not submitted any other document except the Exhibit B about the condition of non-mobility of my mother-in-law due to old age. It is not a fact that my statement and my statement in evidence are completely false. It is not a fact that mother-in-law of the plaintiff executed the will at the old age. It is not a fact that my mother-in-law living together with the plaintiff falsely executed the will. It is not a fact that I do not nurture any mother-in-law. It is not a fact that my evidence is false. Now, DW2, Nirmal Uzi. Bulu Das is my sister in relation. I have got a good relation with them. She lives Ishapur Hati. My house is at Ishapur Hati and Korsela is a different place. I stay outside in connection with the service. I do not visit the residence of mother-in-law of Bulu Das always. I do not know their family matter. I have not seen the execution of the will. But Bulu Das told me about the execution of the will and the litigation. I do not know about the land of Buluwala Das. Buluwala Das asked me to give the evidence and I gave evidence. I cannot say what is written in parawise in my evidence on affidavit. I put my signature in affidavit if asked by advocate. I have absolutely no any knowledge. I do not know about the death of deceased, but I know that she was released by the doctor from the hospital. It is not a fact that I gave the false evidence against the plaintiff. These are the evidence, the cross part.
What is exhibit B?
Exhibit is the
Medical
medical certificate.
Medical
Lordship,
certificate.
As per me, this certificate, Lordship, but the certificate was not proved by calling the doctor. It was merely exhibited. So here if we see there some dermatological, some skin problem, disease had some skin problem. But what exactly disease she had, it's very difficult to say. The DW has also could not specify what disease she was suffering. Exhibit B, dermatological problem. Dermo.
But it is not available on the record.
Not available. That exhibit B, my lord,
Yes,
that is not available.
I am not
I
seeing
think it is
it.
there, ma'am.
Kobe. বেলেগ আছে নেকি? এইটো হ'ল উৰি, এইটো exhibit A. Oh, নাই, exhibit 1. সেইটো exhibit 2, exhibit 3. কি নম্বৰ exhibit কৈছে? Exhibit B. এইবোৰ চাব দিম।
Exhibit A, I think exhibit A is the order of the executing board.
Okay, that's it. So is exhibit B is a certified copy? So sorry, it is a discharge certificate.
Discharge certificate, yes.
So it appears that she was admitted at
On 8/6/2012.
8/6/12 and discharged on 27.
8/6/2000.
Then as per this certificate, she was suffering from
Dermatositis and DCMP. my lord.
dermatositis.
And DCMP. On the right hand side, it is written, my lord.
Yes.
DCMP is, my lord, dilated cardiomyopathy, where the heart becomes enlarged and the pumping of the blood is not regular, my lord. And there is a breathing problem also and
It does not.
and edema also.
It does not.
That's why she developed, my lord, skin problem. That's why
No,
she
no,
was kept for 20 days in the hospital, my lord. Her condition was very serious, ma'am.
No, very serious. On what basis you are saying very serious?
Otherwise, my lord, a patient won't be kept for a hospital for 20 days, my lord. Without
No, merely because she was in hospital for 20 days, it cannot be said that her condition was serious.
my lord, in the will also, it is written that she was a patient of heart disease.
See outside.
And
Patient of?
heart disease, my lord.
Maybe.
And if my lord see the signature in the will, it's very shaky, my lord. She was just able to just put somehow, my lord. My lord sees the signature, exhibit 1.
You have not disputed her signature.
It is not
No,
required also,
you have not disputed.
because undue influence is there.
No, how is that? And you have to prove now which.
That, my lord, because the
No, no.
suspicious circumstances is there. That's why he has to prove, my lord. I don't have to prove it.
That is the burden lies upon them to prove that that the evidence is not here. Undue, what are undue? Nature of undue, they must specify the subject. But they have not, they have also alleged the fraud. It is burden lies upon them to prove the fraud, what fraud we committed. But that burden was not never discharged by them, by their side. Your lordship will see, the DW2 said that he knows nothing about the case. It is his evidence, the PW2 said. But on the other hand, the PW, your lordship will see the two attesting witness corroborated each other, all corroborative evidence. They said, yes, she executed. And the will has to be proved like any other cases, your lordship.
No, where is the evidence to suggest that her condition was very serious?
That evidence is not.
My lord, this is the only piece of document that we have given. And plus, my lord.
No,
the cross.
going by that document, can it be said that her condition was very serious?
My lord-
Even she could not put her signature also.
In fact, my lord, it was admitted by in the cross-examination of PW3, my lord. I'll just read out that portion. Now.
Yes. Writing? No, it tolerate.
The English translated copy that my learned senior friend has given.
Yes.
My lord, there it's written, my lord, Phulobala Das had to be taken to hospital before she died. So before execution of the will also, she was taken to hospital for 20 days. Immediately after execution of the will also, she was taken to hospital. Third line, my lord. Phulobala Das had to be taken to the hospital before she died. At
PW?
PW3, cross-examination. Utpaljit Das. Third line, madam. Phulobala Das had to be taken to the hospital before she died. At that time, she was physically weak. And thereafter, my lord, next line, I cannot say who first signed the exhibit 1. He was present there, my lord. Although his contention is that he was present while execution of the will and he had seen the persons putting the signature, but he cannot say
Maybe when the this will was executed.
2012.
2012. And when he deposed before the court?
1/7/2012.
No, when he deposed before the court?
He deposed, my lord, on 2014, my lord.
2014.
2014. Similar statement.
So it may not be possible who had put signature earlier and who put signature later on.
That is vital, my lord, because why I'm saying, my lord. Similar statement has been made by the attesting another attesting witness, that is PW4, that he also doesn't know who has put the signature first. Why I'm saying, my lord, section 63C of the Indian Succession Act, my lord. That is execution of unprivileged will. 63C, I'm reading.
53.
63.
Yes.
63C. The will shall be attested by 2 or more witnesses, each from whom had seen the testator sign or affix his mark to the will, or has made some other person sign the will in the presence and by direction of the testator, or has received from the testator a personal acknowledgement of his signature or mark or the signature of such other person. And this part is important. And each of the witnesses shall sign the will in presence of the testator, but it shall not be necessary that more than one witness be present at the same time. So here, my lord, in the evidence in chief or in the, my lord, application for grant of letters of administration, they have not stated that the witnesses were present in presence, they have signed in presence of the testator, my lord. This section 63 was not complied with.
So you have not.
Plus, my lord, section 281 of the Indian Succession Act, where it specifically states that, my lord, verification of petition for probate by one witness has to be done. That is mandatory provision, my lord. Section 281. Where the application is for probate, the petition shall also be verified by at least one of the witnesses of the will when procurable in the manner or to the effect following so and so. That I witnessed the last will and testament of the testator mentioned in this one, and I have seen and acknowledged the writing and this verification is also missing in the application manual.
But that plea was not taken by you, no?
But this is a legal plea, matter. I can
Before the court below.
Point of time.
That plea was taken.
This is a law point, matter. I can take anything.
No. You have not taken that plea.
I've taken the point of non-maintainability. So this covers all.
Verification of.
And plus, my lord, there is another anomaly in the will. In the will, if my lord comes to the will. Second recital, my lord. Whereas the testator is absolute owner in possession of immovable property fully detailed in Schedule 1. She was not in possession of the property, my lord. There is also defect. That's why, my lord, she filed title suit in the year 1983 for seeking a declaration of right title interest and recovery of possession, my lord. That is in our written objection. I'll be coming to that part.
Person to execute the will. What is the?
Since
that
she
is
was
the-
not in possession,
That
my
is not
lord.
the requirement of law. It is, you cannot say that one must.
अपने call did you my lord? My lord, section. She was not in possession. So this clearly shows that, my lord, this was prepared by someone else without her knowledge, my lord. She filed a suit in the year 1983 seeking declaration of right title interest, recovery of possession. That suit was decreed. That came to the Honorable High Court also, and that suit was decreed by the Honorable High Court also, my lord. Thereafter, because she was not keeping well, she could not file any execution proceeding, my lord. So
No, later on it was filed.
Filed by one of her son. That is the predecessor interest of the present appellants, my lord. He filed the application for execution, my lord, without informing us. And he took money from the judgment debtor, 6 lakhs. That's why, my lord, there is a finding of the learned trial court that he was bent upon taking or receiving benefit over the property, my lord. He took 6 lakhs to compromise the matter. And thereafter, my lord, we came to know about it. Then we filed an application for impletement. And thereafter, we were made party, my lord. So, my lord, since she was not in possession of the property, that this recital also clearly goes to show that, my lord, this was prepared behind the back of the. And she had just, my lord, see the signature, my lord, it's not at all legible. She was so weak, my lord. From the conduct of the petitioner, my lord, conduct of Fulobala Devi also, my lord, this can be seen. And plus the cross-examination part, they have admitted, my lord, that before executing the will, she was in hospital. And after execution of the will also, she was taken to hospital. And, my lord, this DCMP is very serious condition, my lord. And she was very aged, plus 70 plus years.
EC?
DCMP. DCMP is, my lord, dilated cardiomyopathy. And that's why, my lord, on 1/7/2012, the will was executed. And immediately thereafter, after taking to hospital, she expired.
1/7/2012,
the will was executed and she expired on 5/7/2012.
Yes. After 4 days, 5 days.
4 days.
4 days. Then understood.
In the execution proceeding also, my lord, the petitioner side, my lord, the appellant side, they have never uttered anything about the will. And plus, there are certain other contradictions also, my lord, in the cross-examination part, because the PW1, PW2, 3, and 4, they have stated that Fulobala Devi called the witnesses. Whereas in the cross-examination part, my lord, of the PW1, that is the present appellant number 1, Minu Das, she has admitted that my elder daughter Dimple Das called the witnesses. This is one contradiction, my lord. Whereas she has said that my Fulobala Das had called the witnesses, but here in the cross-examination part, my elder daughter Dimple Das called the witnesses. Then, my lord,
who said Fulobala Das call the witnesses?
In their evidence in chief, all the witnesses have stated, my lord, that Fulobala Das call the witnesses. Then in cross-examination of PW4, Sanjit Das, he told that someone called Tutu called him to be the witness. And all the attesting witness were, my lord, from the family members of the appellants, none from the side of the, my lord, Fulobala Das, my lord. His son was there, another daughter-in-law is there, that is the present respondent, my lord. Nobody was there as attesting witness, my lord. Only the family members of the present appellants, they were. PW3, he is the uncle. And thereafter, my lord, cross-examination of PW5, that is the scribe, who is an advocate, my lord. He said that he does not know anything about the attesting witness of the will, although he was present. I wrote the will on 1/7/1992. I do not know anything about the attesting witness of the will. So that means, my lord, these are cooked up stories, my lord. Attesting witness, merely they have come before the court and they have stated and filed their evidence in chief that we are the attesting witness, my lord. And stamp papers were purchased on 28/6/1992. That has been admitted by, not 92, my lord, 2012. 28/6/2012, the date on which Pulowala Devi was discharged from the hospital. A patient, my lord, who is so serious, my lord, that she was counting her days. Will she go and buy or tell someone to buy stamp papers on the day of discharge from the hospital, my lord?
When it was purchased?
28/6/1992, the very date of discharge. Good. Or 2012, 28/6/2012.
Wrongly typed.
So, my lord, considering all these aspect of the matter, my lord, the learned trial court was correct, my lord. Finding of fact was correct, my lord. That Pulowala Das, she was counting her days, and as such, she could not have executed the will in sound health and mind. Sound mind, my learned senior colleague is harping upon the thing that, my lord, sound mind is necessary, but sound health is not necessary. Sound mind will be there, my lord, only when someone is very healthy. Both will coexist together, my lord. Without a sound body, my lord, sound mind cannot exist, my lord. Nice. Judgment get a reason, sir. So I'll be relying upon two judgment matter. 2015 8 SCC, my lord, may take up first. Paragraph number 57 and 58. May I read para 57?
Yes.
Para 57. A will is an instrument of testamentary disposition of property, being a legally acknowledged mode of bequeathing a testator's acquisitions during his lifetime, to be acted upon only on his share, her demise.
So this was taken note of by the learned trial court.
Trial court.
Mhm.
I'll be just reading the para 58.
Not necessary.
But the trial court has taken some other matters, if I'm not wrong. Trial court has not taken up this judgment.
No, this was taken note of. This was authored by Justice Amitav Roy.
My lord, my lord.
It is reflected in the judgment.
My lord. Paragraph numbers should be different, my lord.
In the other judgment?
Other judgment, my lord, 2010 5 SCC 770, paragraph number 9 and 10.
Yes.
Para 9. The first appellate court also noted that it was admitted that the subsequent will dated 25/4/1980 is an unregistered one, and the attested to the said will were alive even though the scribe was not alive. It was also admitted by the appellant that the testator was not well for about 4 months prior to his death. Admittedly, exhibit B19 and B20 were allegedly executed when the testator was unwell. On those facts, the learned first appellate court held that the subsequent two wills being exhibit B19 and B20 were not proved. The High Court held that the findings given by the first appellate court that exhibit B19 and B20 cannot be said to have been proved in view of non-compliance with the mandatory requirement under section 68 and 69 of the Evidence Act is a correct finding. The High Court found that the first will, which was executed in 1972, was executed while the testator was residing with the plaintiff and his wife and another son in joint family in his residential house at Vilupuranam, but the subsequent two wills, exhibit B19 and B20, were executed at Kadalur, where the first appellant was residing. The fact remains that in the first will, no provision was made for the first appellant, but in the second will, two wills provision were made in favor of the first appellant, and they were allegedly executed when the testator was staying in the house of the first appellant. Those two wills were also executed in couple of weeks prior to the death of the testator. So holding this, my lord, the appeal were dismissed. So here also, my lord, it is their case that, my lord, the testator was staying with them. So the case of undue influence is very heavy, my lord. And here, my lord, after 2 weeks, the testator died. In our case, after 4 days, my lord, she expired. And in the Honorable Justice Amita Roy judgment, my lord, it is there that, my lord, the will, my lord, if there is a suspicious circumstance, my lord, then it is the burden is upon the propounder of the will, my lord. That is upon the person who is filing the case for letters of probate to prove that, my lord, there was no suspicious circumstance, my lord. Paragraph numbers also. So separated thus, my lord, I said that, my lord, the learned trial court was correct in holding that, my lord, the will was not proved as per law and there was suspicious circumstances.
I have also submitted the some judgment, Your Lordship. You will see.
Pardon?
I have also submitted the some judgment.
Yes.
Yes. In one case, my lord, your AIR 1977 SC 63. In this case, within the 5 days after execution of the will, the executor died. Executor will died.
In which case?
Yes. AIR 1977 SC. Para 1, para 1, 9, 10, 11 para.
So why you were referring so many cases?
So many cases because all the judgment your lordship will see what is the requirement of the law. Requirement. Whether the perfect health is required. Perfect health is not required.
Okay, we'll see.
Lordship will see the all the
Heard Mr. Upadhyay, learned counsel for the appellant, and Mr.
A. Iqbal.
A. Iqbal, learned counsel for the respondent. Argument concluded, order reserved, judgment reserved.
Well, I'll just point out one more thing. The will also does not speak, my lord, as to why the other sons were not given any property.
Other?
Other sons,
that
is the husband of the present respondent, why he was not given any share. The will is also
Husband of the?
present petitioner, respondent, my lord. Fulobala Devi had 3 sons, my lord. She gave the property to one of the, not to the sons, my lord, but to the daughter-in-law and to her granddaughters.
That
As
has
to
been
why the other sons were not.
stated in the will itself. They already got separated.
It is very vaguely written, my lord. They have been given other
They were-
properties. Where are the properties there? She
Yes,
got
sir,
only
but
one property.
Is it not written in the?
My lord,
mentioned in
it's
the-
written in the will as, my lord, as they were given other properties, so I'm not giving them. But what other property? She had only one property. So this is the only property she had.
No, you have
So
got
these
stated
cast
all
serious
these
doubts,
things
my
here,
lord.
how he can make a submission before this lordship
My lord,
about this
there are judgments
disputed
these
fact.
effects, my lord. This is-
You have
Okay,
not
okay.
stated anything about this in the
Okay,
court
okay.
below.
Okay.
Item number 22.
So Mr. Mozumdar, let us fix another date. Some order has to be passed, which I have already heard. Yeah, due to want of time. Hearing of this matter is then adjourned to be listed when?
Lordship, can it be
After
possible of
vacation.
26/9?
No, no,
possible,
sorry.
Lordship,
Before vacation, not possible.
Then Lordship.
Same thing will happen.
Lordship. Then 29, Lordship.
After,
no.
After reopening of
Before-
1 week, Lordship, 29th October, Lordship.
Lordship,
October.
not
Yes.
possible.
Okay.
Lordship, October not possible. but
Why?
I am not available.
Acha.
That's-
Maybe he's going for Umrah Hajj,
In
Lordship.
the first week of November then.
Then 5th November, Lordship.
5th of November, okay,
Yes.
okay. Any other matter?
Item 23, with
Right.
Lordship, kindly pass over the matter for the day, Lordship.
Okay, as agreed by learned advocates of both sides, this is at least the
Lordship,
matter.
we have some objection in this matter. It's a long pending matter, Lordship. It's an old pending case. So can it be fixed after, immediately after reopening, Lordship, on 24th October? It's a
Okay, okay,
Thursday, Lordship.
okay.
item 28.
Obliged, Lordship.
Lordship, in this case, kindly a date may be fixed, Lordship.
Okay,
Any date after puja vacation, Lordship.
yes,
On 5th November.
Obliged, Master.
as agreed by. Right.